Kaurua e rangi e tūnei, kaurua e papa e toto nei. Kaurua ngā kōrero ngā wānanga, kaurua e te kauhanga nui heputanga ki te whaiau ki te ao marama kaurua. Kaurua moana hawa mai ai o ki te manga hawa mai ai o te putanga o te ari ki manga hawa mai ai o te putanga o te tipua manga hawa mai ai o te putanga o te tauira, he tauira. Ka e ke rongorupe, ka e ke tiro mahuta, ka e ke rangi tāhua hua kai au te tauranga taku tū te Māori tū. Te whiwhianu ku tū puritia mai roto, tāwhia mai roto, tēnei te Māori, ka whakapiki tēnei te Māori ka whakakake. Te Māori o ngāri ki kauhia ki runga ki enei taura, ki runga ki enei tauira, enei rua nuku, enei rua hine ka whakamau kia tīnā. Tīnā hui e, tai ki e, kia ora tātou.
Tēnā koe te pāpā i te whakatūwhero o tō tātou nohoanga a kia koutou katoa, he mihi anō, nau mai hoki mai ki tēnei uiuinga. Mr. Lyle.
Morena, Your Honour, without wanting to take up too much of the time we have, we've spoken amongst claimant counsel. Everyone is going to be as tight as they possibly can on the time remaining. We also anticipate that there'll be some savings in the time allocated for the brief oral closing submissions and possibly in time for the Crown re-examination, but that remains to be seen. So I propose that we proceed now, and then if we do see that there might be a need to perhaps shorten the lunch break up slightly or take steps like that, then we can do that as we approach it. The only other thing I'd say is that on the proposal for a joint brief oral closing statement, claimant counsel have agreed that Ms Earl and East Hope would present on behalf of all counsel, and we're just firming up a hand-up of those brief submissions and should have those to the tribunal as soon as possible, but it's not going to be a rolling mall of counsel presenting submissions and will be kept brief, Your Honour.
Thank you, Mr. Lyle. That's very helpful. So in terms of time allocation, for now we will simply work off the most up-to-date order that was handed up yesterday.
Yes, Your Honour.
Okay. I can also indicate for counsel that Tāpou has advised if any counsel run over, he is going to put a makutu on you and turn you into a frog. So you have been forewarned.
It'll certainly work on the Māori lawyers. Still working out the 5% threshold for the Pākehā ones.
Mr. Binion.
Thank you, sir. Tēnā koe, Ms Marsh, and thanks for your long day yesterday. And I've just got some tidy up matters, I think. Can I just go first to the meeting of the 21 May, should we call it a slightly infamous meeting? It's making the press. I just noticed in that meeting minutes, there's a moment where the Minister of Treaty Negotiations talks about 1% of the coastline going to be subject to CMT, and then later talks about 5%. So you're clear, the Minister used both those
What's
expressions.
recorded in the note, tēnā koe whis. What's recorded in the notes was what was discussed at the meeting.
All right. And where the minute says under paragraph 13, the Minister said the veto right made sense, only if 1% of the coastline was going to subject to CMT. And then he says, he said three things he was going to get from the meeting were, and C is section 58 commitment. That was a commitment to who?
I don't know what he meant by that.
All right. But should we expect that he's in a room with seafood industry? He's making a commitment to the seafood industry that the Section 58 change will happen. Is that fair?
No, probably my read of that is the commitment to the coalition agreement to amend.
Right.
Yeah.
Okay. And the question I had too was why is there no formal comment from Minister for Oceans and Fisheries about this policy? Why is there no policy paper or response from that minister to the policy, Section 58 change?
I can answer that.
Okay. But so this is the actual only moment where the Minister of Oceans and Fisheries actually is commenting on this Section 58 policy?
At a meeting that I've been present at,
Yes.
there are other meetings, committee meetings that the Minister would have had that I wasn't at, and none of the officials would have been at.
So when we come to the policy and the final cabinet paper, it talks about legitimate interests in the foreshore and seabed. Does that include the commercial fishing interests?
Sorry, could you ask that again?
Well, when we come to the final cabinet paper, let's go to page 503 of the common bundle. In paragraph 44, it says large water CNT on the basis of lower threshold test established by the Court of Appeal may challenge New Zealanders' expectation that the Act protects the legitimate interests of all New Zealanders in the common marine area. Do we assume that, where does the seafood industry fit here?
All New Zealanders?
Just while we're there too, can I just check? I just want to check through the way some words are used. First of all, in the coalition agreement and in your council's opening submissions, he makes the point that coalition government will reverse measures taken in recent years which have eroded the principle of equal citizenship, and that's the reason for this policy. That there's been an erosion of the principle of equal citizenship. Why are the words equal citizenship never used in any of these documents, in any of these briefings to the Minister?
Our focus was on the amendments rather than, we never had a discussion, as I said yesterday, around equal citizenship and that lens being applied.
Why not?
We were focused on the Section 58 part of that.
Okay, so you're aware, are you, that the MACA Act in 2011 had to go to the Attorney General to get a sign-off because there was a worry that the MACA Act was actually taking away from Māori rights in the foreshore and seabed. Do you understand that? It was discriminating against Māori.
I understand that.
Right. So the MACA Act on its face was eroding Māori rights in the foreshore and seabed, but the opinion of the Attorney General was all of the regulatory rights and things that Māori were going to get under the MACA Act were going to justify that limitation on those Māori rights. Do you understand that?
I understand that.
Yes. So on its face, the idea that the MACA Act and the Court of Appeal judgment is an erosion of the principle of equal citizenship doesn't make any sense, does it?
It's a coalition agreement.
So why do you, when you're looking at putting into effect a coalition agreement like this, is there a moment where you go back to ministers and say, what does equal citizenship mean?
As I said, we were focused on the amendments to Section 58. Okay.
Can I just go to page 27 of the Common Bundle? And this is the infamous, I keep using that word, but the page we looked at with the chart on it and the handwriting from the Minister. And as I read that handwriting down the bottom, page 27, do you see it's on the last line it says, and real concern potentially, it seems to say real concern for expectation of New Zealanders to have equal say. Now, just looking at that line, and it's hard to read, we can clearly though read the word expectation and the words equal say. Do you see those there?
I do.
All right. So now when I come to page 52 of the Common Bundle and paragraph 19, 32 of the Common Bundle and paragraph 19, and we've got this paragraph. There is concern that the potential implications of recognition of CMT over a large amount of the coast than previously anticipated will have an impact on New Zealanders' expectation of having equal say over the management and use of the coastline. Is that the moment where those handwritten words from the Minister enter the policy process? Is that what we should understand there?
I can't confirm that. But obviously the notes that the Minister wrote were considered and included.
All right. Now, you agree, don't you, that the idea that there's an expectation of having an equal say is absolutely antithetical to the whole idea of the MACA Act, isn't it?
That's you. I understand that's your statement.
But no,
What's the question?
logically, isn't it? Because the whole point of the MACA Act is that Māori are going to have a right to veto consents on the coastline, aren't they, in some areas?
So your question is?
Well, if the advice here is there's an expectation of having an equal say, that's not what the MACA Act does. It doesn't do that at all.
I can't, with the MACA Act is what the MACA Act is.
All right. And when we see the word equal say there, and then I want to come to the final Cabinet paper at 503, and paragraph 44, and we were just at that paragraph earlier. Large awards of CMT may challenge New Zealanders' expectation, there's that word again, that protects the legitimate interests of all New Zealanders. Do you know at what time somebody said, well, we're not going to use the words equal say, we'll change that to legitimate interests?
I do not.
And is there any analysis anywhere in these documents, because I can't find it, of what equal say means or what legitimate interests mean?
This is the Minister's voice and views.
All right. Yeah, 5 minutes, good. Okay. A couple more things. The Fast Track Act. Oh, no, one more thing, actually. On that 21st May meeting, the 21st May meeting, I did note that at the end, it just abruptly stops. Do you see that? It doesn't have a sort of... The 21st May meeting just... the last line is 20. The Minister of Oceans and Fisheries said that while the Waitangi regime created de facto marine reserves. Is that all of the meeting? Why doesn't it finish off with some sort of comment of the Minister thanked the representatives, as happens with the Ngāti Koata meeting?
All I can say is that this is accurate note to the meeting. It won't include, it's not verbatim,
All right.
but it accurately reflects the conversation that was had at the meeting.
Okay. All right, thank you. And then on fast track, you appreciate that the fast track legislation that the government's, the bill that's been introduced, provides that fast track proposals can't proceed in CMT unless CMT holders give their permission. Do you know
It's
anything
not
about that?
not my area of expertise.
So do you know you haven't seen any conversations about how the fast track legislation might be affected by these changes?
The only conversations that I have been part of is ensuring that it's understood the bundle of rights, the bundle of rights under the MACA Act that are available to those who hold CMT in the development of our policy team's advice on the RMA fast track.
So it's possible another government department dealing with fast track might be looking across and talking about these Section 58 changes? That's a possibility?
I'm not aware of that, can't answer that.
All right. Oh, and here's a question someone asked me to ask. Well, actually, I'm involved in this. We're preparing some evidence for a hearing in Taranaki next year, right? The evidence is due to be filed. What's your advice to applicants in preparing evidence for it? The hearing is set down for early next year, and we have to file our historical evidence. I think we're going to do that in October. What do you say applicants should be doing? What sort of evidence should they be preparing? Should they be preparing for the new test or the old test?
On specific cases, I would recommend that they come talk to Te Arawhiti, to the Te Arawhiti Takutai Moana team, to talk through what that might look like in terms of what advice we can provide. And that'd be around funding and whatever support we could provide.
All right. Thank you. Those are my questions.
Thank you, Mr. Binion. Mr. Sharp.
Tēnā koe.
My name is Michael Sharp, and I'm just going to really ask you some quite focused questions about the process where you arrived at the final proposed amendments to Section 58. So that starts, and I wonder if we could bring up the advice paper of 27 May 2024, which is at Common Bundle 110. That's the advice paper that leads to those changes being made. And while we do that, so in your brief of evidence, you summarise what happens in that process at paragraph 105 to 109. You have a look at that. Have you got those paragraphs?
I have.
So just to summarise, so at 106 you say that the Minister's view of Parliament intent of high threshold with few CMTs was not correct. From the record, parliamentary intent was less restrictive. And then I think in your paper at paragraph 34 you said it was not a demanding test and a common law-based test, not as strict as Foreshore and Seabed Act. Is that a summary? Yeah. So then you move on to 108 and you say, notwithstanding the coalition agreement and parliamentary intent, ministers could decide to make changes for a CMT test, a more demanding test that would reduce the number and size of CMT orders and adjust the balance of interests in the purpose section. That's a summary? And at 109, you say there was scope within the present cabinet paper proposals to do this, to define the test, and you go on in paragraph 43 of your advice paper so that you can do that by including definitions of exclusive use and occupation similar to that established in the Canadian jurisdiction. That's correct? That's paragraph 43 of your advice paper.
Where it starts theoretically?
Yes, at paragraph 43. I'm just referring to, that's correct? Yes. So if we move on from there to the next stage, it said that the present cabinet paper, this is at paragraph 44, 45 of your advice paper, for amendments to CMT were intended to address errors in the Court of Appeal in line with parliamentary intent. But if you want to go further and to encompass the Minister's policy intent, you need to make more drastic changes, including to the purpose. That's correct?
I think the interpretation is they're open to pursue further changes.
Yes, but you're
Yeah.
saying you have to do some more work.
Yeah.
So if we can go to the work that you finished up doing, so if we can go to the final cabinet paper at paragraph 448 of the bundle. And if we look at can you go to the changes that were proposed, which is at paragraph 47? Have you got that?
Not quite.
Paragraph 47, option A. You got that? So when we look at the change for the tests, 47.2.1, change the test that exclusive use and occupation relates to exclusivity over the whole period, 1840 to today. I'm presuming that that was intended to address the Court of Appeal, to correct the Court of Appeal decision, where they...
The interpretation?
The interpretation,
Yes.
to make it clear it intends to
clear.
1840, yes. And then it goes on to include exclusivity against third parties, and that substantial interruption includes any sufficient interpretation regardless of its nature. So I think you referred before to change a test to a literal test. So the intent for that seemed to be literally that Māori have to have the legal ability to exclude others from the MACA area at all times from 1840 to the present.
I think my words were in line with the literal words of
Yes,
the test.
yes. So that's
Yeah.
that's intent. Okay. Now, this is I just want to identify it. So this is going to be a change from the present test, the present approach, because I think you discussed in the High Court that they have tended not to apply the exclusivity test literally, and in particular, they don't take into account times when Māori rights to exclude others were not legally enforced, and that's at paragraph 26 of your previous memo. So that's your description of.
Sorry, could you direct me to that?
Yes, paragraph 26 of your previous memo.
Being
27.5, which is at, from 110, if you go to paragraph 26.
Sorry, Mr. Sharp, can I just ask which page number you're referring to in the common bundle?
So that's at page number 116. So you see that down the bottom, 26, that they've tended to exclude others, not taking into account where there's been no legal mechanism for available to exclude others, Māori to exclude others.
sorry, and your question is sorry.
Well, that's the approach that the High Court had been taking, wasn't it? That they hadn't been taking a literal approach to excluding others. They've been adjusting it for situations when Māori can't legally exclude others. That's correct?
You know, in the that's not my area of expertise, but what I can confirm is that statement there.
Yes.
Yeah.
And do you realise also that in the Court of Appeal, a similar approach was taken to not include for exclusivity when Māori can't exclude others? Were you aware of that?
Again, not my area of expertise.
Were you aware that under the Canadian jurisdiction, they had the same approach, that they didn't apply the test literally?
Again, not my area of expertise.
Were you aware
But to
that
assure you that we do have good legal advice at Te Arawhiti.
were you aware that your literal test that you're suggesting is contrary to what the common law authorities were to that point of time?
Again, not my area of expertise.
And Ms. Marsh, just generally in providing advice to the Minister on taking an approach to the Act that changed the previous parliamentary intent to a more exacting test, did you advise him that that was potentially in breach of the Crown's Treaty of Waitangi obligations?
If you're asking me, do we have advice on whether it's consistent with the treaty?
Or did you advise the Minister?
We have received advice, and that advice is privileged.
Right, thank you. And just a final question, Ms. Marsh, I was just interested in that, in your advice to the Minister on the potential effect of the Court of Appeal decision in Edwards on the amount of CMTs. You don't seem to provide any advice that the Court of Appeal had sent back to the High Court CMTs in the open ocean and made observations that it would be difficult to obtain CMTs in the open oceans. Did you discuss that at all with the Minister?
I don't recall that specific conversation.
Thank you, Ms. Marsh. That's all my questions.
Tēnā koe.
Thank you, Mr. Sharp. Ms. Mason.
Tēnā koe, Ms. Marsh.
Tēnā koe.
I don't have too many questions for you. I just wanted to advise you before starting that my client's case, I act for some clients from your area, Ngāpui, and their case is that this idea of the Court of Appeal getting it wrong, it's all just a facade, that that's not the real reason why the Act is being changed. And just a very general question, would you accept that the role of interpreting legislation is something that sits with the courts, not with the public service?
I think I'd go back to Parliament being sovereign. It's a, yeah.
Right, so Parliament passes legislation, that's correct?
Again, just like yesterday, I couldn't name the AG, couldn't give you a definition of the Crown. I fear we're going to go down that track.
I'm just asking you a question. Parliament passes legislation, that's correct?
Yes.
You answer, and the courts interpret it, that's your understanding?
Yes.
Okay, and so it's appropriate that the courts interpret that legislation or say what it means?
That's appropriate.
Okay, all right. Now, I just want to go to paragraph 106 of your brief of evidence that my friend Mr. Sharp referred to. And that's, just wait. So that's the paragraph that my friend referred to and many of my colleagues have referred to. You talk there about the minister's view, which is different from Te Arawhiti's view, that the test was intended to set a high threshold. And you talk about that the minister's view relates to, or it's implied in here, that it was based on internal political discussion. What do you mean by that?
Well, he was around at the time.
Right.
And he had discussions with his colleagues.
So you mean
and
that's...
his read of what was intended.
Right, from the National Party point of view.
I can't say what discussions he had or what informed his view, but it formed his view.
All right, okay. You were aware that at the time that legislation was something that could not have been passed unless the Māori Party gave their votes?
I am.
Okay. Did you go and look at the National Māori Party relationship and confidence and supply agreement?
I did not personally. I can't confirm whether the team working on the review did or not.
Okay, so in your exercise, Te Arawhiti's exercise of finding out what the intent of the legislation was, you didn't look at the National Māori Party agreement?
I can't confirm that here.
Okay, all right. Sir, I have copies of the agreement here, if they could be passed to the registrar. Have you got a copy here? Yes.
Do you want me to have it?
I have some questions on it.
Okay.
Yes. Thank you.
Is there another copy?
Is there another copy? The registrar will have one. Apologies. So I just wanted to go to just a couple of places in here. So under the introduction, in the third paragraph, it says, both the National Party and the Māori Party will act in accordance with Te Tiriti o Waitangi, the Treaty of Waitangi. So in terms of assessing the intent of the legislation, you would agree that it was meant to be consistent with the treaty?
I would agree that the parties that that agreed to this agreement, that was their intention.
And it's the same parties that negotiated and passed that act, wasn't it?
Yes.
Okay. And if you go to page 2, in the last paragraph under foreshore and seabed, it says, in the event that repeal of the legislation, that's the Foreshore and Seabed Act, is necessary, the national-led government will ensure that there is appropriate protection in place to ensure that all New Zealanders enjoy access to the foreshore and seabed through existing and potentially new legislation. Would you accept that the primary reason for protecting New Zealanders' interests was at that time about access, New Zealanders' access to the beach?
I can't speak to what the primary purpose was at that time.
Okay, but it says there in that agreement that was in
Then that's what it says in the agreement. That's what was agreed at that time. I can't speak to the thinking behind that.
Okay, and that's reflected in the purpose of the Act, isn't it? At section 4 of the Act, there's a lot of recognition on customary interests, and there's this recognition of access as fundamental.
So Ms Marsh doesn't have a copy of the Act in front of her.
So if you go to section 4(2)(e), it's the recognition of public rights of access, navigation and fishing. Right? So that was a fundamental purpose of the Act. Do you accept that? Okay, all right. And then I want to take you to page 32 of the bundle. And in particular, if you've got page 32, at paragraph 19, and that says that there's a concern that the potential implications over a larger amount of the marine coastal area than previously anticipated will have an impact on New Zealand's expectation of having an equal say over the management and use of the coastline. So I put to you that this concern of access originally morphed into a concern about coastal management and resource consents. That's correct? Fair to say?
No, it says there is a concern the potential implications of recognition over a larger amount of marine coastal area than previously anticipated will have an impact on New Zealanders' expectation of having equal say over the management and use of the coastline as originally intended by the Act.
Okay, so that management and use is about Resource Management Act consents, isn't it?
That's not what the words say.
Okay, well, who manages and uses who manages the use of the coastal marine area?
What do you mean by manage?
Well, who issues resource consents? What legislation is that under?
Again, not my area of expertise.
Okay, well, it's the Resource Management Act, and you wrote about it in your paper, so you should know a little bit about it.
I didn't personally write about it.
Okay, but you signed these out.
I
That's
did
why
sign
you're
them
here.
out. I did sign them out.
All right. So it's the Resource Management Act. So I'd like to go to the page that everybody else has gone to, which is 27 of the bundle. And this is that summary, and with the minister's writing at the bottom. And the section that he writes about, or the bubble, is what is the problem we are trying to solve. And of course we know that Te Arawhiti has written that it was about the Court of Appeal. And the minister writes, and he essentially says that more of the coastline is going to customary ownership, and it's going to be expensive, and that it's really not fair or not good for New Zealanders not to have an equal say. That's what he's saying, isn't it?
That's your interpretation of what he said.
Well, that's what it says there. Can you read out what it says?
No, it says this has led to a real probability that most of coastline, I can't read the rest, I can't read it, the rest of it.
Falling
Ownership.
to customary ownership. And then it says hugely expensive process to determine overlapping claims. And then he says, in real concern for expectation of New Zealanders to have equal say in what happens.
And that's what he said.
Yes, and that's the real reason, isn't it? That's the real reason why these amendments are being put into place.
Yes, so what's the real reason? Sorry, what's
What
your
he's written
interpretation
there.
of the real reason?
It's not the Court of Appeal, it's what he's written there. The real concern is about expectations of New Zealanders to have an equal say in what happens in the coast.
He's clear in the Cabinet paper about his concerns and the reasons.
Yes,
for
so
the
that's,
amendment.
I put to you that that's the actual reason. It's got nothing to do with the Court of Appeal decision, hasn't it?
What is in the Cabinet paper reflects the Minister's views in his voice.
All right, all right. Those are all my questions. Thank you, sir.
Thank you, Ms Mason. Now is it Ms Hiruini? Tēnā koe.
Ai, tēnā koe te kaiwhakawa. Tēnā koe Ms Marsh.
Tēnā koe.
Ko Ms Hiruini tōku ingoa. Ko māua ko Ms Evans e whakakanohi ana i ngā kreme e toru kāre kore I rongo koe I te rātua tahi, ko ngā tirehia te tahi.
Ai.
Ka re kore mohi ana koe ki a rātou, no te tai toke rau.
Ai.
Ngāti tamau nupo, no whaingaroa hapa me ngā karanga hapu o ngai te hapu. Nō reira, e mihi ana ki te rāhuatanga. I just have two specific points I'm hoping to raise with you, and I'm hoping you also have in front of you a document that we filed earlier this morning, sir. You should also have that in front of you. Can I ask whether you have it? It's the Cabinet Circular of October 2019. Kapai. I had raised in, obviously, in the evidence of our clients, they speak quite heavily to tikanga and in their view, the trampling of their tikanga in this process and the proposals that are being made. So that's quite a focus for them, because obviously they heavily and strongly embody their tikanga and how that relates to their takutai moana. But that's viewed in two ways, in the way that they see the interpretation of the courts have of the Act, that it actually bears to the forefront of mine tikanga and how that's considered, but also in the process that they've had to undergo under the Act. So if I can ask the registrar to bring that up on the screen. Are you familiar with that document, I should ask?
Which document?
The Cabinet Circular of October 2019.
No.
You're not familiar with that's a document, and as I understand, that lists a checklist of questions for policymakers to consider in developing policies.
Since this was just provided this morning in terms of a cross-examination document, I wonder if Ms Marsh could just have a couple of minutes to read through it.
That's fine. I just refer up there on paragraph 1 at least to the purpose of that document. It's a document that's agreed by Cabinet in terms of how policymakers should provide their advice that is consistent with and gives effect to Te Tiriti o Waitangi. You see that there? But I just wanted to take you to something specific in terms of tikanga and how that is incorporated in policy making, policy advice that's given to ministers as well. So that's at page 12 of that Cabinet Circular. And obviously I acknowledge that you're not familiar with that document, but I don't think that that question is specific to this document. But what it asks there, can you see page 12?
I can.
The question there is, how does the proposal demonstrate that policymakers have looked at the issue from the perspective of tikanga values? And then it again lists that 75 tikanga principles there, mana whakapapa. Can I just ask you, in your policy development and your role, did this happen?
I would say yes, tikanga is one of the considerations.
In the advice that you provided and in the policy development, are you saying that the issues were considered from a tikanga perspective?
No, I wouldn't claim that.
You wouldn't?
I wouldn't claim that. I would say that the focus was on being very clear around the direct impact on a taonga tuku iho.
And one of those direct impact as well as you'd accept as tikanga and how their tikanga is impacted effective?
I'd accept that.
You'd accept that? So you said no, and I just asked you why was tikanga not considered in this policy development?
And like specifically, yeah, I've said
Specific to
I've
your
said
role
I could not claim that tikanga lens was placed over the policy development. It's not a claim I could make.
Would you accept that it wasn't that the minister wasn't concerned for tikanga and his considerations of the issues before?
The minister's concerns are contained in the cabinet paper and in comments that are and through the documents that we've supplied.
And I asked you why not, when we look at the provisions that are being proposed to be amended, all of those provisions, 58, 10, 106, the preamble, Te Tiriti o Waitangi section, and section 4, they refer specifically to tikanga, all principles of tikanga. So would you accept that that's quite a significant shortcoming in the policy process?
What I would say is that, as I said earlier, we have received legal advice on the consistency of the proposals with the treaty, and that advice is privileged.
But you'd accept that obviously it was absent in the policy process of considerations to tikanga. You'd accept
Sorry,
that?
can you confirm what was absent?
Tikanga considerations were absent.
I confirm that I would not claim that a tikanga lens was placed over the policy development process.
Ka pai. I'll just move to my second point, and that's really just speaking to the risk analysis of impacts on Māori applicants under the Act. Our clients they have quite different places in terms of where they're at under the Act. Ngai Te Hapu, you would have heard, have been a part of the Ngā Pōtiki Stage 2 hearings, which took place in 2021. So their case in which their matter has been heard and awaiting judgment. Ngāti Tamanupō had an indication that hearing would take place by at least mid-2026, so they were in preparation phase for that hearing. And Ngāti Rehi, on the other hand, they're very unique in that they don't have a MACA High Court application, but they're engaged in the Crown. They have an application under that route, and the evidence that was put, at least from their perspective, was that they felt at that time that that was a good signal of good faith relationships with the Crown to direct their attention to having consultation, well, having direct engagement with the Crown. And so I guess my point I just wanted to discuss with you is when they hear of meetings being had with groups like the seafood industry, before they even knew any detail of these changes, you can, and also there was evidence put that they haven't heard anything about the application since it was filed in April of 2017. So you can accept and understand why that's quite concerning for the claimants in Ngāti Rehi, at least in that respect. You could accept that?
My comment would be that the purpose of the meeting with the seafood industry, regardless of the discussion that was had at that meeting, the purpose of it was to discuss the seafood industry's concerns with public consultation and the cost of that.
And there was a particular concern as well around the Crown engagement process and how they could participate in that?
No, the difference between the Crown engagement process and the High Court in terms of public consultation. And what I understand is their right to test evidence in the High Court. It is not so in the direct Crown pathway, Crown engagement pathway. So they submit under the public consultation process. Their submission is then taken into consideration and assessed and provided in a report to the Minister, which is different than the High Court, I understand.
But you can appreciate how, at least from perception, that Ngāti Rehia haven't heard anything in terms of their specific Crown engagement from the Crown, but yet the Crown have met with interest groups such as the seafood industry. You could accept that that's concerning.
If that is Ngāti Rehia's concern, that is Ngāti Rehia's concern, and I respect that.
Ka pai. And just you speak on the various interest groups, such as, for example, commercial interests. You'd agree that they remain unaffected in the proposed changes?
I don't, till we get into the draft, well, we're in the drafting, the detail.
As it currently
impacts.
stands, have you assessed any potential risk to those groups?
On commercial? No,
No,
not to my knowledge.
but you've accepted the impact to Māori applicants, so you'd agree with me that the only groups proposed to be disadvantaged by these proposed amendments are Māori applicants?
Yeah, I think I'd accept that that they will be impacted.
And they will be the only groups
Those
disadvantaged by the
that,
proposed.
yeah, I'd accept that they'd be impacted.
Ka pai. I think I will leave my questions there. Tēnā koe, Ms. Marsh.
Thank you, Ms. Herwini. Mr. Clackworthy?
Tēnā koe te kai whakawa. E pai ana ki noho hau, sir. I have a submission to read from the Attorney General, and I'm a bit tall for having no lectern. Pai ana. Nā mihi, sir. Tēnā koe, Mrs. Marsh.
Tēnā koe.
Ko Mr. Clackworthy toku ingoa. Ke konea hau mō Ngāti Tuwehi no Aotea Harbour me te hiko o Papauma no Waitarapa. Tuatahi e rere ana ngā mihi mō tō kōrero me tō whakaro ato mōna kaikareme. Kei te ronga rātou i tō wangawanga mō rātou. So, ngā mihi. He te aku pātu pātai no iho mau, so you'll be glad to hear that, as it's been a long couple of days.
Ka pai.
So the two MACA claimants who I represent have recently completed their hearings but are currently awaiting judgment. That is Ngāti Tuwehi, who took place in the Aotea hearing, which was from 17th June to 5th July. Finishing at the start of last month, and Tiko Papauma, who took place in the Waitarapa hearings, 1A and 1B, but principally 1B, which finished in May of 2024, and 1A judgment is released, but 1B is still awaiting their judgment. So, as per the announcement of Minister Goldsmith on 25th July, both of these applicants are likely to have their cases overturned and sent back for rehearing. Mrs. Marsh, if we can just go to your evidence from A48 at paragraph 165, please.
Sorry, 145?
165, I believe, of your A48 evidence. Not the summary,
This. Aroha mai.
I can find the summary as well.
Right,
Paragraph 165.
that one? Yep. Ka pai.
Okay, te pai. So it says there that those applicants who, as at 25th July 2024, are awaiting judgments or whose applications are part heard are the most impacted by Cabinet's decision to propose respective legislation. That's correct?
Yes.
Yes. Mrs. Marsh, I'd just like to point you to an exhibit. You wouldn't have read this, but it was filed with the brief of our Ngāti Tuihi claimant and kaumātua Ronald Miki Apati, who can't be here due to poor health. Kia pakita ore te rangatira. Registrar, could I please get you to bring up document A5 bracket A on the ROI? Ngā mihi. And please, I see you've got paragraph 58 and 59 there. So this document is a portion of the closing submissions of the Attorney General from the in Aotea Harbour hearing. I'll just read it out for you because I know you won't be familiar with it. So if you can see here, Mrs. Marsh, if we can read ka tīmata, paragraph 58. The Attorney General submitted in this case that the evidence before the court supports a finding that the two applicant groups, who were Ngāti Tuihi and Ngāti Whakamarirangi, in this case, together hold the area in accordance with tikanga, and that use and occupation of the harbour, Aotea Harbour, from 1840 to the present day has similarly been shared by the groups who appear to have varying degrees of authority and control across the area. At paragraph 59, the Attorney General concludes that a finding of shared exclusivity therefore appears to be appropriate in this case. So essentially agreeing that on the evidence the Section 58 test has been met. My pātai, Mrs. Marsh, is, do you agree that in situations like this, where the hearing has been completed, where the Attorney General has been a part of the hearing process, has tested the evidence, and has submitted that on the evidence it appears that the Section 58 test, or conceded that the Section 58 test has been met, that it would be further prejudicial, or at least for the claimants, it would feel more prejudicial and more of a hara on their nāko to have to go through a rehearing under a new test when the Attorney General does not dispute that the applicants have satisfied the current Section 58 test?
What I can respond to that is that the decision around the impacted case is the decision at this time. It's the initial initial proposal.
Kei te pai. Furthermore, just one more question. Do you agree that removing the retrospectivity aspect of the proposed changes would remove the possible prejudice that the claimants face or feel that they do face by having to go back to a rehearing?
I think the views that we shared with the Minister that are recorded, that is our view.
Reflect that, yes.
Those are our views. What is recorded and communicated to the Minister, that
Yes.
is those words are an accurate reflection of our view.
Yes, and I believe that they reflect that it would remove the prejudice to the claimants if they did not have to go through a rehearing.
That's your interpretation.
Yes, that's
of
my
that.
interpretation.
Okay.
Ngā mihi whaia Marsh. I don't have any further questions for
Ngā
you,
mihi
and
kia
thank you for
koe
your
hoki.
evidence. E rere ana ngā mihi.
Thank you, Mr. Clatworthy. Mrs. Irwin Easthope.
Tuatahi e te whanaunga he kurangi maunga mai tēnei Ngāti Pūtanga, ki a koe te whānau a hene rupe mai tiki tiki ki te araro tēnei tāua, me mihi hoki ki o karanga, whakapapa karangataha ki a ngā puhi hoki. Sir, I'm not going to proclaim height, but I have a non-youthful knee injury, and since I'll be on my feet later, I'd prefer to sit. And then I'm also at the level of Miss Marsh, which I think is a bit more helpful. Ms Marsh, just to remind you, I act for Te Runango Ngāti Awa, for Ngāti Awa, and so I'm grateful for both your evidence here before us and you being here, you know, he wahine Māori, for the Crown, anō, and I want to acknowledge that, and also the ground that my friends have covered. So what I'm going to try to do is just kind of step up or pull us back a little bit, because my friends have traversed a lot of material with you, and I don't seek to go over that ground again. But just to remind you, I will address some questions to you about what I spoke in openings about Trona's unique circumstances, a few questions on intent and policy intent about the Supreme Court judgment in Edwards Supreme Court hearing. So that's kind of where I'm going. Were you here yesterday when Mr. Ruben Araro gave evidence?
I was.
Ka pai. And have you read his evidence or the summary in your, I think you've said you've referred to or read summaries of the evidence?
Summary of the evidence, not Mr. Araro's specifically. Did
Ka
you
pai.
want?
No, kei te pai, but do you recall his evidence yesterday in terms of the summary of the thrust of it?
I recall it was compelling evidence, and talked to the importance of the takutai.
Ka pai.
I recall that.
Thank you. In your evidence at paragraph 167, and I think this is one of the concluding paragraphs, you note, perhaps I'll just note what I think is the sentiment, that the Crown, it's been helpful for the Crown to read the evidence, to sort of fully appreciate the potential issues, and you note particularly where some members of the same groupings will be considered under a more stringent test. Do you recall that?
Yes.
Ka pai. And do you acknowledge that Ngāti Awa falls into that category?
Yes.
Ka pai. I'm certainly not trying to trick you, Ms Marsh. Ngāti Awa unfortunately does fall into that category. It has you might remember the A3 that I handed up, which kind of explains how they've had to participate in the process. You don't need to go there. No. I'm not going to ask any further detailed questions about that. And my friend Ms Hedawini this morning has already talked to you about implications following the Reader Stage 2 proceeding, which we don't have a judgment for yet. Perhaps if I just step back, would you accept that this is quite complicated?
I would totally accept that.
Ka pai.
It's not straightforward. It's complicated.
Thank you, Ms Marsh. So I'm going to move to intent, and I said on Monday in openings that on the face of the Crown's own documents, the sort of cloak of restoring Parliament's original intent because of the Court of Appeal decision in Edwards was a farce. Do you recall me saying that?
I think I recall several people saying that.
Ka pai. Perhaps I should just say I did say it. And at paragraph 49 of your evidence, which is page 11, and again, I'm not going to take you through this in detail because my friends already have, you note that because the coalition agreement had no detail or direct criticism of the Court of Appeal decision, it was therefore important for Te Arawhiti to ensure in its first briefing that it obtained sufficient policy direction from the Minister.
Yes.
Ka pai. And then at page 50, you go on to talk about that first briefing on 21 December 2023, and I wonder, Madam Registrar, if we could just bring that up on the screen. It's been well traversed, and I don't intend to take you to particular parts of it, but just note something at the outset. Sorry, that's at CB tab 1. And I think because it's the first tab for Mr Crosby, I think it's page 1. Document number TA 0030004. It's the 21 December briefing to the Minister. Thank you. And if we could just scroll down to paragraph 1A. I think it's on the next page, sorry. And I think multiple members of my friends have taken you to this. So the context is the coalition agreement. And again, my friends have noticed that there's no reference there to this equal citizenship premise. And again, just stepping back with the benefit of hindsight, which we now can do in August from December. If you had the time again, do you think you would have pressed the Minister on that intent?
That thought hasn't, I haven't entered into that thought. So what do you ask? What's your question?
So the question is, with the benefit of hindsight, so you've heard that applicant groups have an issue with this really being the intent. So coalition agreement says we're going to amend section 58 to make clear Parliament's original intent. And we keep coming back to that. And that, of course, is within the context of this equal citizenship premise that you've noted that you haven't provided advice about. If you had the time again, the question is, the benefit of hindsight, would you say to the Minister, or would you provide advice to the Minister here that says we need to be clear about what that means?
Yeah, I think you've raised the benefit of hindsight. In all things, you could do things differently. But I would be speculating, or I'd be theoretical. It's not something that I could answer. Yeah, in hindsight for all things, and in this process, I don't think that we don't claim that we have done everything perfectly, and we would do some things different. That's the benefit of hindsight.
Thank you, Ms. Marsh. And this is really, I think, for clarification, because my understanding of your evidence and the advice provided is that, do you agree that retrospectivity, accepting that this came in sort of late in the piece, isn't required to do that, to do what the coalition agreement said?
We provided our views in terms of retrospectivity.
Kapai, and you would say that they accord with what I've just said, that that's not required, retrospectivity is not required to achieve the coalition agreement?
Views on retrospectivity. What we did say was, and I am being careful here, we said at some parts, no reasonable justification for overturning and retesting existing CMT.
And I'll get to that point, existing CMT. I think that's fine. I understand your answer. I'm not going to do it immediately now, but I just want to flag something that I'm going to come to shortly about sort of what the court's doing in finding that applicants have met the test for CMT, and then the effect of that when there's no sealed order, but we'll come back to that. And so just sort of taking what I've said in relation to intent, do you understand where Ngāti Awa's coming from when they say, look, this is a farce?
If that is Ngāti Awa's perspective, I accept that.
Thank you.
Could I just add, in terms of other recommendations that Te Arawhiti made in terms of retrospectivity, the briefing in 27 May?
Yes.
We say our recommended option is to agree that any changes should be prospective only, with transitional arrangements for applications currently mid-process. That's our recommendation to the Minister.
Thank you, Ms Marsh. And very briefly, I just have a specific question about the LDAC advice, which is at, for Madam Registrar, tab 4, TA 0010294. And we don't need to go to a specific page number. I just want you to see it so we can sort of orient ourselves as to what we're talking about. Oh, page 49 is the...
I've got it.
Kapai. We'll just wait for Kapai. So you covered quite a bit of ground on this with my friends yesterday. I'll just make sure you recall this document.
I do.
Kapai. And are you able to confirm whether LDAC's advice here was prompted because drafting instructions to Parliamentary Council Office had begun?
No, I can't confirm that. I don't recall it being at that. It hasn't been till quite recently. I don't recall this advice coming during that period.
Okay.
Yeah. This advice was provided to the Minister.
Yes. Do you know what prompted, do you know what prompted the LDAC advice, seeking LDAC's advice at that point in time?
I think, we were wanting to ensure that the information that we were providing to the Minister, again, that he was considering all the risks and implications for the proposed amendments. And so I think it would be prudent to get their advice and further independent legal advice. So it's part of that process.
Thank you, Ms Marsh. I just have two discrete questions on engagement. The first comes from one of my friends. We just want to check. So you discussed, I'll use Mr Benion's words, the infamous meeting with Mr Benion this morning, and we just want to double check that there are no other meetings you've attended with the likes of Landowners Coalition or any other third-party groups?
No, there isn't. I was going to say pleasantly they've been with applicant groups.
Ka pai. Thank you for confirming that, Ms Marsh. And then second question on engagement, does the Crown view this tribunal process as part of its engagement with applicants?
I don't know. There hasn't been a discussion. Yeah.
Okay. And then two final points, and this is what I flagged earlier about this distinction between awards and orders. So, and we'll see how we go, because it might be something that we can just address in submissions, but if we could go again, Madam Registrar, to the 21 December briefing at tab 1 of the Common Bundle, and I'm going to go to Appendix 3, which we haven't gone to yet. It's at pages 13 to 14. Ka pai. So this is my understanding of what this is to say to the Minister in your briefing to him, here are the determinations that have been made, and here are the number of CMTs determined and enacted. So I see the difference between determined and enacted on the basis of my read of this document as CMT determined means there's a High Court judgment, CMT enacted means that there's sealed orders. And are you aware that under the Act, there is only a CMT when the orders have been sealed by the court? Are you aware of that?
I'm aware of the order. Yeah, that's the sealed bit. Something I learnt yesterday.
Ka pai. That is a bit weird. What I'm getting at, though, is that a lot of the Te Arawhiti advice focuses on CMT awards, and so you use the phrase CMT awards when you're talking about the High Court judgment in Edwards, the High Court judgment in Reader, and I'll just stick to those because they're the ones that I'm familiar with. Whereas actually both of those cases, well, one of them we don't have a High Court judgment, the other is going to be before the Supreme Court. So at the moment, there is, on the basis of Te Arawhiti's own advice to the Minister, one CMT order sealed to date in Re Tipene, and that's the High Court order. And then I think about 17 others that have solely come from Tō Tawa Nei Iwi, Ngāti Porou, so that other quite discrete process. And I don't need you to confirm that for me, it's in the documents, but I guess my point is that when I read the advice, I thought, is that distinction being drawn to the Minister's attention? Because in my view, it is quite an important distinction that actually you don't have all of these CMTs around the country at the moment at all. You have awards, so High Courts have made determinations. They're either subject to appeal or in the Pāhauera case, my understanding is that the Court of Appeal has actually said we're going to wait for the Supreme Court, so you don't have the Court of Appeal going and doing its own thing. So do you think that distinction comes out in the advice?
Not to the detail that you've described, no.
And do you accept that could be quite important?
I've noted what you've said, and there are other Te Arawhiti officials in the room. So I note that that's important.
Ka pai. And so final might be three questions. Just in relation to my friend Ms. Cole's question to you yesterday about haste, so sort of what is the rush here? And my understanding is that I think your response could amount to that you don't know, like there isn't a reason necessarily to rush other than the Minister's preference.
Their views are in the Cabinet
Yes.
paper.
Yep.
Yeah.
Do you accept that one reasonable inference that can be drawn from the haste that has been taken seeking to pass amendments before the end of the year, that one inference that can be drawn is that they want to do it before the Supreme Court issues its judgment in Edwards?
I could see how that might be a perspective.
Ka pai. And in your view, as the Deputy Chief Executive responsible for treaty reconciliation and takutai moana, which I can only imagine how big a job that is the process that the Crown has followed here treaty compliant?
That's something, in terms of treaty compliant and the consistency, we have received advice, and that's privileged.
I don't want to, I'll be conscious of whether my friend puts his hand on the microphone because I don't want to take you somewhere where you can't go. But I just wonder whether that's right. I'm asking for your policy view as the Deputy Chief Executive about process. So, I mean, Te Arawhiti, in my read of your evidence, has advised the Minister a range of times to do things that he hasn't done, and that's, you say, his prerogative. My question is, do you think in your role that the process has been treaty compliant?
What I think in my role is that the advice that we provided around the importance of meaningful and fulsome engagement with Māori on a matter that significantly impacts their rights and interests was an essential thing to do.
Do you not want to answer my question directly?
That's my answer.
So is your answer then that the process that you advised the Minister to take would be treaty compliant?
My answer, engaging with Māori in a meaningful way is part of being treaty compliant.
And do you think engagement here has been meaningful?
No.
Ka pai. Thank you, Ms Marsh. Now, my final question, I've sort of really struggled whether to put this or not. I won't bore you with the details about why, but I think part of it is kei te mōhio hau he taumaha tēnei pātai. He taumaha tēnei mōku, kāre e kore he wahine Māori koe he taumaha tēnei pātai mau hoki. So my view is, and certainly a number of the claimants have expressed this in one way or another, but I'm not sure if it's been asked directly, certainly been noted in openings, is my view is there is a level of racism here. And I want to ask you if you agree.
Around racism?
A level of racism in the proposals.
Yeah, I can't answer that. I'm not prepared to answer that.
Okay.
I haven't thought that through. You know, we're focused on providing, genuinely, a task at hand, focused on providing the best information we can to the government to inform decision making. That's the focus here.
I appreciate that, but why I put it to you is because the focus of your advice is taking place in a context, and it's taking place in a context where Te Arawhiti has a specific role in the context of its provision of the advice to the Minister. So I don't expect you to say anything further if that's your answer, but that's why I put it.
It's a challenging environment. Accept it's a challenging environment. I'd say for most Māori in the public service right now. I think someone said it's intense and it's a choice. So,
but it's not a choice for these applicants.
No, but the question was around my opinion on whether there was a racist element. And my response to that is it's a challenging time for Māori in the public service. We choose to be here.
Ka pai, and I appreciate your mahi. Those are my questions. Thank you, Ms Marsh.
Thank you, Mrs. Irwin. Hope, Mr. Lau.
Kia ora, sir. I'm not sure if Mr. Irwin is online, but we are running slightly ahead of where we were, and I understood he did have potentially one or two questions. So perhaps if we could check with him and then...
Mr. Irwin, are you with us?
I can see I'm with you all. Hopefully you're with me too. And Ms Marsh will be very happy to hear kaere kau he pātai nā kū mā hau Ms Marsh, engari te mihi kia koe te māngai mo te karauna moe nei take. As you know, Ms Marsh, I act for Ngāti Koata, and after reflection, we have no questions for you. Engari te mihi. Kia ora.
Tēnā koe.
Thank you, Mr. Irwin. I also note that clearly the threat of Tāpou's makutu worked because, unlike yesterday, today all counsel were undertime rather than overtime. So perhaps I should wave that stick more often. But Ms Marsh, again, I just want to acknowledge and thank you for the evidence that you've provided so far.
So it's Ms Sykes here. I'm a late arrival because I was in other courts. But I'd like to ask, I have a watching brief for the Ngāti Ira or Waiawika claimants to the Supreme Court, and I've been following the questions by ABL and by in my presence when I had finished court, which I have now done. I have some questions that I'd like to ask Mrs. Marsh, if the tribunal permits. I'm hopeful they will only take 5 minutes, sir, but I have been instructed to ask them, particularly in light of the answers to Ms. Irwin, who's East Hope this morning.
Ms Sykes, I'm conscious that Ms Cole spent some time questioning this witness yesterday.
She was acting for the applicants mainly. I was here in the watching brief only for Ngāti Ira, who is directly affected by the Supreme Court matters.
5 minutes, Ms Sykes.
Kia ora, Mrs Marsh. Kei te tuku mihi kia koutou, I whakarohia me pēhea te huarahi tōtuka mō tō tātou nei tiriti. I just want to follow up on your role as policy advisor. Do you have any guidelines that assist you in assessing discrimination?
I'm not aware of that.
So, notwithstanding that in previous findings of this particular subject matter, of the discriminatory nature, for example, of the Foreshore and Seabird Bill, which involved the United Nations Special Rapporteur visiting New Zealand on these matters, you have no policy guidelines to assist you in assessing discrimination?
I can't confirm that. So we have our policy kahui, and I could get you that information, could follow that information up for you.
So you're only seeking for it now. You didn't actually seek or reach for it when you were doing your policy advice on the treaty compliance or otherwise of this particular proposal?
I could confirm that for you.
No, you don't need to confirm it. You signed a paper that my friends have taken you that gave policy advice. As part of that policy advice, did you reach for or make inquiry of any material that will facilitate you in advising on whether or not a policy proposal is discriminatory against any particular citizen in this country?
Again, Ms Sykes, I wouldn't, I don't want to confirm something that I'm absolutely not sure on. So we can provide you with all the information around the considerations that were undertaken in the development of the policy.
So
and we can provide that information.
My specific question then relates to the third advice for the Committee on the Elimination of Racial Discrimination.
We can provide that confirmation.
Can I answer the question and then I'll let you answer it? And whether or not the guidelines and the recommendations that were made then were actually taken into account in providing advice to ministers about their present conduct.
Sorry, I didn't quite understand the last part of that.
When the Foreshore and Seabird Bill happened, there was a particular report by the United Nations Committee for the Elimination of Racial Discrimination, and that made significant findings around how you provide a policy framework which may elevate one sectors of the community rights above or devalue another sector of the community's rights. And that report is quite significant in the policy framework that then resulted in the MACA Act. I'm asking, did you refer to that report at all when you assessed this policy proposal that came from the coalition agreement?
And my response is I can confirm or not that, but not right at this time.
Thank you. I have no further questions.
Thank you, Ms Sykes. Ms Marsh.
Kia ora.
We do have some questions for you as well, but again, I just want to acknowledge the evidence you have given and the frank evidence you have given, not only in writing, but before us yesterday and today. I just want to start briefly with the issue of parliamentary intent, and I know you've been questioned at length about that, so I'm not going to spend much time on it. But I just want to briefly address two issues. So yesterday, you told us about the advice that Te Arawhiti gave to the Minister on Parliament's original intent, and ultimately the Minister took a different view. You also referred to the sources that Te Arawhiti relied on when preparing that advice. And one of those sources was statements from Crown officials in the Stage 2 MACA inquiry. Now, Mr. Naden handed up a cross-examination bundle when he was questioning you yesterday. Do you still have a copy of that? So if you can turn to page 184 of that bundle.
Thank you.
So this document are answers in writing from Benisa Smith to questions from Counsel. And as you discussed yesterday, Ms. Smith gave evidence on behalf of Te Arawhiti for the Stage 2 inquiry. And if you look at the top left-hand corner, you'll see the first question from Mr. Naden to her. And he refers there to the comment from the former Minister, Mr. Finlayson, and it's in quotes, "Any areas of territorial interests will probably be small and discrete and will not necessarily overlap with areas of valuable minerals resource." And the following question is that the test in section 58 is designed to ensure that any areas of territorial interests will be small and discrete. And then to the right you see Ms. Smith's answer. And there she says that she recalls there being a divergence of views amongst officials and ministers on this point. To her knowledge, no policy decision was made in the design of the test for customary title under the Marine and Coastal Area Takutai Moana Act to ensure that it would result in only small and discrete areas being recognised. This contrasted with the Foreshore and Seabed Act 2004 framework, where the recognition of only small and discrete areas was a policy consideration that underpinned that Act. So there's a fairly clear statement from Ms. Smith on that point. Is this one of the sources that Te Arawhiti relied on when it was preparing its advice?
We list it, I think we list it within our review.
Because it appears to be...
The primary sources, I think. There may have been others.
It appears to be consistent with the advice that you gave to the Minister.
Yes.
So just stepping back then, we have the advice that you gave, and we have some of the sources that Te Arawhiti relied on giving that advice. And ultimately the Minister took a different view. Are you aware of any sources or authorities that the Minister relies on to support his view of Parliament's intent?
Only his views from his experience, his understanding at the time.
Is there anywhere in the Crown bundle or in your affidavit where I can find any sources or any authorities that the Minister relies on to support his view of Parliament's original intent?
Not to my knowledge.
I'll just move on to consultation. And again, I don't have many questions for you because you've already given a frank assessment of whether the engagement here for these amendments is meaningful. But I just want to make sure I understand what engagement is actually being undertaken. So I understand that there is a 3-week period for providing feedback?
That ended on the 15th of August.
And so what was the start period for that? Was that 25 July?
25 July, the date of the announcement.
And in terms of the engagement that was available for that 3-week period, did that include the opportunity to have face-to-face hui, or was it only to provide a written response to the Cabinet decision?
The Minister met with 4 groups in the Crown engagement pathway. around the proposals being Rongo Mai Wahine, Ngāti Parau, Te Whānau Apanui and Ngāti Koata? Ngāti Koata. So those were the only ākanohi hui that were had.
So for the others, their only opportunity was to provide a response in writing?
Was to provide a response in writing.
Now, just looking at those dates, 25 July to 15 August, I'm just wanting to also look over that period and what was going on for those claimants. Now I understand that as part of your role, you provide briefings to the Minister on what is happening with this urgent inquiry and also what is happening with the MACA applications.
We have provided weekly updates in a summary form, discussed at officials with our legal advisors.
Because this 3-week period we're talking about, by that stage, this urgent inquiry was already well underway. You'd be aware, obviously, from the last 3 days, if not earlier, that there are a number of applicants who are engaged in this inquiry.
Yes.
Some of those applicants are also currently appearing before Justice Harvey, having their claims heard in Whangarei.
I'm aware.
So for those groups, not only was there a 3-week window, it was a 3-week period where they were having to prepare for appearances before this tribunal and also before the High Court for those who have applications there.
I acknowledge that.
And given the briefings that you have provided to the Minister, he would have been aware of that at the time that he determined this engagement process and period.
The Minister was definitely aware of the tribunal hearings. I can't recall whether we specifically we provided him with the timing of the hearings.
Presumably in your role you would have briefed him on all of the fixtures that had been set down for the High Court.
We have.
And when it comes to the ability of Māori to engage within this short time frame, juggling these many commitments, all they have to look at this stage is the Cabinet decision?
That's right.
There's no draft bill to consider?
The bill is in draft process.
But it's not available for them to review to
Not
respond.
until, my understanding, until introduction.
And you've also commented earlier today about how complex this legislation is, and presumably any amendments will also be complicated.
Yes.
Particularly given that the amendments are going to make changes to the purpose, preamble and treaty clause, which could have wider implications for the whole of the MACA Act. And I think you've acknowledged that in your advice. So it's very difficult for Māori to be able to provide meaningful responses when they haven't actually seen the detail of the bill. That's fair, isn't it?
It's at this time, that's fair.
And once the bill is introduced, the only ability for Māori to engage from there will be through the select committee process.
That's my understanding.
I just want to come to the issue of a balancing exercise. And in your evidence, and I can take you to the section that you may not need to, but you did refer to the 2011 Act that the government wanted to establish a regime that balanced the interests of all New Zealanders. You recall that?
Yes.
And that was a key objective underpinning the whole of the MACA regime.
Yes.
Does the Crown say that these amendments here are part of a balancing exercise.
Sorry, could you explain that?
Yes. So previously we were told that the MACA Act is part of a balancing exercise. It's about balancing the rights and interests of Māori against the rights and interests of the wider public, and that there's a balance that goes on in terms of what the MACA Act does. In terms of the amendments that are now being proposed, is the Crown also saying that this is part of a balancing exercise?
I think the Minister and the Cabinet paper, or the Minister's view in the Cabinet paper, and I'm kind of like paraphrasing that, is to bring it back into balance.
Yes. And I think he said that there's an imbalance at the moment. Have you had an opportunity to read our Stage 2 report for the MACA inquiry?
Not for some time.
Okay.
And I admit I've read the summary.
Okay. I was just wanting to raise with you our findings on the principles that apply when the Crown undertakes a balancing exercise, because it will be relevant for some of the later questions that I have for you. So this is at page 10 of that report. First, we referred back to the findings of the Tribunal when it reported on the Crown's foreshore and seabed policy. So this is what the Tribunal said there. We accept that the Crown has the authority to develop a policy in respect of the foreshore and seabed. However, the principles of reciprocity and partnership require it to do so in a way that gives meaningful effect to te tino rangatiratanga and balances the interests of both peoples in a fair and reasonable manner. So that's what they said concerning the first foreshore and seabed policy. We then commented further on that in our report, and we said, in addition to being fair and reasonable, any such balancing exercise must also be principled. It cannot be arbitrary, particularly where the balancing exercise has the effect of restricting or impacting Māori rights. Mm-hmm. Do you recall those findings through the summary you read?
Not word for word, but the what do you call it? The underpinnings of them.
Okay. So, where the Crown is undertaking this balancing exercise, it has to balance the interests of Māori, it has to balance the interests of the public, and it has to take into account those principles that I've just referred to. Coming to these amendments, are you able to assist me with what is the public interest that has to be protected by increasing the threshold for the test for customary marine title?
So, again, I can only point you to the Minister's views in the Cabinet paper.
I'll just go to that with you, and I may just need a little bit of help initially, because I see, you may have explained this already, but there appear to be two versions, one at 448 and one at 497. Are they both the same, or is one a final version?
So the one at 448 is the first version, and that went to the Cabinet Economic Committee and was considered then on the 1st of July by Cabinet. And then at that point, Cabinet deferred consideration of the Section 58 issue for a week, and the Minister was asked to submit a revised paper. And the difference between the one at 448 and the one at 497, the key difference, is the inclusion of paragraph 9.4 at page 516. So the Minister was asked on the 1st of July to do some more thinking about retrospectivity, and there is advice in the bundle from officials about that. And then 9.4 is the new additional retrospectivity option and the one that is ultimately adopted by Cabinet.
Thank you, that's very helpful. So if we go with the version in 497, if I can ask you to turn through to page 507. And halfway down the page there is a conclusion there. So paragraph 72, the Minister states, "I am concerned that the recognition of CMT over a larger amount of the common marine and coastal area unsettles the balance of rights intended by the Act." So there's that phrase which tends to indicate that he is undertaking a balancing exercise here to
Yes.
rebalance it. 73, large and more awards of customary marine title on the basis of the lower threshold test established by the Court of Appeal in Re Edwards may result in significant portions of the coastline falling under CMT. And then 74, the increased difficulty of getting resource consents across a large portion of the coastline would challenge New Zealanders' expectation that the Act protects the legitimate interests of all New Zealanders in the common marine and coastal area of New Zealand. So just with those comments in mind, is that the best evidence that we have of the Minister's and Cabinet's rationale behind these amendments?
That is, yes.
Okay. And I think you may have already been questioned about this, but we don't have any evidence of what the Minister is relying on when he refers to New Zealanders' expectations of the Act and the legitimate interest of all New Zealanders.
Not any documented evidence.
There's nothing in the bundle which supports what he's referring to
Not
there.
to my understanding.
But if we read those paragraphs together, he appears to be saying that a concern is that if there are too many customary marine titles granted, it's going to impact the ability of others through the resource and consent process.
And unsettle the balance of rights
Yes.
that he understands was intended by the Act.
Yes, and I infer that the big concern there is the ability under a customary marine title to veto a resource consent.
If that's your inference.
Well, he's referring there about the increased difficulty of getting resource consents as a result of customary marine title. That could only be referring to the right to veto, couldn't it?
Again, this is the Minister's view, and I would not reinterpret his view.
Okay. Now, I just want to spend some time with you now exploring the many steps the Crown has already put in place to protect the public where there is a customary marine title in place. And we reported on this in detail in our Stage 2 report. Do you recall that from the summary?
No, I don't.
Okay. Well, I'll just go through these various protections with you, and you can let me know if you're familiar with them or not. I'm assuming you'll be familiar with most, if not all. So first we have the big three of access, fishing and navigation.
Yes.
Those are clearly protected and are excluded from any right of veto. You agree with that?
Yes.
And that fishing includes both recreational and commercial fishing.
Yes.
There is the caveat to that a claimant group can also seek a wāhi tapu protection order.
Yes.
That requires a separate test to be met in front of the High Court.
Ka pai.
And even then, when you receive a wāhi tapu protection order, that can't prevent both commercial and recreational fishers from taking their lawful entitlement.
Yes.
So there is still protection for the fishing industry there.
Yes.
We then have those areas of the marine and coastal area that are not the common marine and coastal area. So the areas that have been excluded from the CMT regime, which includes reclaimed land and freehold titles.
Yes.
So neither of those can be subject to customary marine title. Those interests are protected. Do you agree?
Agree.
We then come to the accommodated activities and the accommodated infrastructure. And there's some rather long and complicated provisions there.
There is.
And again, we report on it in detail at stage 2. I won't take you through all of them, but there are just some that I want to touch on because they are particularly relevant here. So one of those for an accommodated activity is where there is an existing resource consent that is in place. Where there's an existing resource consent, no right of veto, the holder of the resource consent has the ability to use that to the end of the term. Are you familiar with that?
Yes.
And coming back to the seafood industry, because there has been some talk about that in this inquiry, we've already spoken about fishing rights, but for aquaculture, there's a specific protection for aquaculture in the accommodated activities provision.
Yes.
So they still enjoy the same protection that if they have an existing resource consent, they can enjoy that to the end of the term.
Yes.
But for aquaculture, they can also renew their resource consent, and again, there's no right of veto. Do you agree with that?
Yes.
And not only that, they can change the species that they fish, they can change the type of fishing, and there's still no right of veto. Are you aware of that?
That detail's getting a bit detailed.
It's a bit
Yeah.
too technical? Okay. It's section 64, subsection 2E is the relevant provision, if anyone is interested in pursuing that further. So that covers renewal, which you're aware of. So there are protections there for existing resource consents and then for aquaculture for renewal. We then come to new resource consents. Even if someone is applying for a new resource consent, as long as they get their application in before a customary marine title is sealed, even if it's not granted, as long as they file it, it's still not subject to a right of veto. Are you aware of that?
Not to that level.
Okay. And this touches on a point that Ms. Irwin Easthope raised with you earlier about the difference between getting a judgment and getting a sealed order. And just to help a little bit with that, so where the court makes a judgment, it will in there contain its decision. That may include a grant of customary marine title. After that, though, there is a separate formal step where an order is drafted and sealed with the stamp, and that's the sealed order that gives effect to the judgment. Does that help to explain how that process works?
Thank you.
Okay. So in this case, where we have judgments that have been made, but orders have not been sealed, even in that case, those who may be concerned can still rush out, file their applications, and as long as they are lodged with the territorial authority before that order is sealed, they are still not subject to a right of veto. Are you aware of that?
No.
Okay. So the reason I'm raising this is the Crown has already taken significant steps to protect the public interest under the existing provisions of the Act. Are you able to assist me? Is there any other public right or public interest that is not protected by those provisions that now has to be further protected as a result of these amendments?
We've never had any discussion around that.
Okay. And just to confirm, there's nothing in your affidavit or in the Crown bundle which can point to a further public right or interest that is currently not protected, that needs to be further protected through these amendments?
Not to my understanding.
The last question I have for you, and I'm grateful to Council who have covered most of the issues, is coming back to the balancing exercise that was referred to by the earlier tribunal who considered the foreshore and seabed policy. Because there's two parts to it. One is, yes, you have to weigh up what is the public interest that you're weighing up in terms of taking that balancing approach. But you also have to do so, or the Crown has to do so, in a way that gives meaningful effect to te tino rangatiratanga. And because it's part of that balancing approach, you can't just look at the public interest. You have to say, okay, what's the public interest, what's the Māori interest, and where does the balance lie? Can you assist me with where the Minister has made that assessment to provide for tino rangatiratanga in a meaningful way as a part of these amendments?
I cannot.
So just to confirm, there's nothing in your affidavit or in the bundle which shows the Minister assessing how these provide for tino rangatiratanga in a meaningful way?
No.
Thank you, Ms Marsh. Those were the only questions I had for you. I believe my panel members also have some questions for you, but again, I just want to acknowledge you for your evidence.
Tēnā koe.
Oh, sorry. I see after all of my warnings, I'm the one to run over today. Hopefully Tāpou will forgive me and I won't return as a frog. So we will adjourn for the morning break, and perhaps when we reconvene, Mr Stevens, I might invite you to provide an update, if you have one, on the date for the introduction of the bill. So we will adjourn and we'll reconvene at 11:10. Kia ora koutou. Mr Stevens.
Tēnā koe. E te kai whakaoa. So you've asked me to provide an update in terms of, with some more detail beyond mid-September for the introduction of the bill. What I can safely say is that it is anticipated that Cabinet will meet to discuss the introduction of the bill on the 15th of September and make a decision at that point. And then clearly it's important for, it's important for the tribunal to report prior to that time, assuming that that time frame proves correct, which I believe it will, insufficient time for Cabinet to be informed of the Tribunal's report and any recommendations that it might make. The 15th is the date at which Cabinet would meet.
Yes.
And so in order for Cabinet to take into account what the Tribunal has to say on the subject, in advance of the 15th,
yes,
several days in advance, I suppose, would be my indication.
Thank you, Mr Stevens. That's very helpful.
Thank you, sir. Yes. Ms Marsh has just pointed out that the 15th is a Sunday. Cabinet doesn't meet on Sunday, so the 16th would be the correct date that Cabinet would meet.
Thank you.
Thank you.
I only know that because my husband and my
Kia ora, Ms Marsh. I just wanted to start by addressing a couple of additional matters to that list that the judge took you through of ways in which the public interest aspect of that balancing exercise has been protected in terms of the Act, and just ensure that you were cognizant of those. And the first of those that I wanted to just raise with you was the permission right, or rather the fact that the permission right can be avoided in terms of the Resource Management Act if big players have a big project and put the effort and the money into it. They can propose a plan change to a resource management plan which can provide permitted activity status for activities. Were you aware of that?
at a higher level around, you know, not specifically big players, but at a higher level, what that is. Yes.
Right. And the reality is, for any major development or major use in the coastal marine area involving resource consent processes, it's going to involve some significant ability to fund that. Would you agree with that as a general proposition? So that when the Minister is talking about the ability of all New Zealanders to, or his concern that their ability to seek a resource consent might be limited, in a practical sense, we're looking at infrastructure developers, possible seabed mining utilisation, now oil and gas exploration, other possible infrastructure relating to discharges of stormwater, things of those nature, all of which require major capital, all of which involve major players. And do you accept that?
I accept all of those activities that you described would require major capital investment.
And you are aware, or have you looked at closely the
the second schedule to the Act and the processes by which new infrastructure or seabed mining or mining of non-crown minerals is provided for in the Act?
I have read the Act some time ago, not closely on the issue that you're raising.
And you'd be aware that there are mechanisms in there, particularly for the infrastructure development or new accommodated activities, for a ministerial waiver of the permission right. You're aware of that?
I am aware.
Yes. And it has coupled with it, to be fair to the Crown, it has coupled with it a compensation right for Māori, both in respect of a new infrastructure and in respect of mining of non-crown minerals.
Accept that.
Yes. So if we look at, again, and hopefully you've got it before you, that tab 12 to Benicia Smith's written responses, which were put in by Mr. Naden. So it was in the Y2660 inquiry B114G.
Sir, we're just getting, Mr. Crosby, we're just getting that document.
Thank you. Sorry, page 184. 185, sorry. But if we can start, just before we move to 185, I just wanted to draw your attention to the, His Honour took you to the first answer that had been given, where the statement was made, and it's a considered statement because it's given in writing in response to written questions. And the statement was made by Benicia Smith that no policy decision was made in the design of the test for customary title under the Marine and Coastal Area Takatai Moana Act to ensure that it would result in only small and discrete areas being recognised. And then that was repeated in answer 2. To my knowledge, no policy decision was made to restrict the recognition of customary marine title to small and discrete areas. It's repeated at the bottom of page question 5, answer 5. As stated in my previous responses, the test was not deliberately designed to be restrictive or to maintain the greatest amount of non-nationalised minerals and Crown ownership. And then over the page, that answer continued, is answer 5. I can say that one of the policy objectives of the regime was to ensure the awards for customary marine title were meaningful and practical, including providing the opportunity for commercial benefit. So, measuring a proposed amendment intended on the Minister's wording, and the only wording that we've got from him, of 1 to 5% of the coastal marine area in a spatial sense, can that realistically ever be said to be meaningful and practical?
What I can say, I do recall us raising that there was a deliberate policy decision and around the less restrictive. That's, I can recall what we said then. But sorry, that mightn't answer your question, if you want to pose your question again.
No, look, I'm probably being unfair, and people have constantly been unfair to you trying to justify a minister's stance. So I've raised the issue, and it can be addressed by counsel for both sides in their submissions.
The policy issue that has raised here, I do recall in one of the many briefings us pointing out that it was a deliberate policy decision to reflect Benicia's corridor here.
Because I must say, I'm perplexed in that 2 years ago we sat in this building and we heard an ex-Minister of Treaty Negotiations, a QC then, KC now, Mr. Finlayson, in essence proudly making exactly that point, that he was proud of the fact that he had ensured that there would be a meaningful CMT for Māori, that they would be entitled, for example, and he gave the example of the mining of non-crown minerals as being an opportunity for commercial benefit for Māori. And I do not recall there being suggestions in the course of that hearing of there being any particular spatial extent concerns being adhered to at that hearing. He was challenged about a statement he'd made at a yacht squadron about low percentages, and he was challenged too about a statement that the Prime Minister John Key had made in Parliament, and as I recall the response, it was effectively along the lines that probably those statements should not have been made. It certainly did, and when I reread our report, we didn't get the feeling that there was any particular concern about spatial extent of the CMT awards. Now, the problem that I'm struggling with is that now suddenly 2 years later we're being told by another minister that there is a serious problem with these consents, and the judge is taking you through, and so have I just with earlier questions, the types of activities that might be the subject of resource consents. And when you look at those, there seems to be protection all the way for access, fishing, navigation, accommodated activities, and on the list goes. Is there anything new that I'm overlooking that this minister has drawn to your attention or in the Cabinet paper as to a particular problem that has arisen with granting of resource consents?
No, there isn't, and the Minister, as in our briefings shows, was aware that we, in coming to our view on less restrictive, that we had reviewed the tribunal evidence and statements from officials too, and that's all I can offer. We have no other evidence of the Minister's views other than what is in the Cabinet paper and in his notes.
That level of being perplexed also applies really to a different issue, or a couple of different issues. And it's, I've really got to express a view that I am perplexed that the public generally and ministers, it would appear, still struggle with responding to complaints from non-Māori claimants about the CMT regime. For example, the meeting with the seafood industry representatives, it just defies logic why that should have been necessary, or why their involvement in the litigation should be necessary when the provision in the Act is just so plain. Fishing rights preserved in Section 28. Nothing in this Act prevents the exercise of any fishing rights conferred or recognised by or under any enactment in a rule of law. And then the judge has taken you through all the protections for aquaculture. What is, from that meeting, what was your understanding of the nature of the concern?
As I said, the purpose of that meeting and what we briefed them for was around the public's consultation process that they had expressed concern about. We were not asked...
Yes, I remember you saying that, and I've read that in your affidavit too. But what I'm really going is going beyond that and saying, well, why do they need to be involved? What did they express a concern that was advancing their interests, or that their interests were under threat in any particular way?
My understanding is that both the High Court and the Crown engagement pathways provide for them to make, as a third party interest, to make submissions.
Now, I'm just taking it one step further. When you have a section in the Act specifically saying nothing in this Act prevents the exercise of any fishing rights, and then you have the aquaculture provisions protecting them, what aspects of concern did they raise at the meeting in relation to their activities that they said required them to be consulted or be involved?
Anything that they raised is contained in the file note to the meeting.
Okay.
There was nothing, it's not verbatim, as I said before, but it accurately covers what was traversed at that meeting.
And I suppose the same observation applies really in respect of the advertisement that we've been hearing about. When you look at the protections of access, protections of navigation, protections of fishing, as I've just outlined to you, it is perplexing that there is that level of ill-founded understanding of the Act at the present time, some 13 years after it was passed. Is it not something that that Tarawhiti could have just easily responded to with a, because it's a terrible thing to say to you, but as I understand it, the media nowadays are only interested in sound bites, essentially. So rather than giving them a page and a half, literally 3 lines saying the public have absolute rights of access, navigation, fishing, guaranteed in the statute.
Yeah, I think, you know, again, and we could always do things better. We could always do things better.
Right.
Mm.
Right. The only other point that I wanted to canvass with you really related to basically the Minister obviously having some concern, which we're struggling with as to exactly what underlies that and where is the evidence relating to it. But he has some concern about this resource consent permission right. Did anybody in Tarawhiti think about going outside the box and looking at alternative options as to how that might be addressed? And if I just give you a couple of examples, one of the emphases that we gained from the Crown on the first hearing was that the bundle of rights, as it was termed, was instead of compensation for the fact that whilst the Act said that the rights, customary rights were being restored, immediately the same subsection went on and said, whoops, in accordance with this Act, so you were limited to the bundle of rights. But the Crown approach before us was that bundle, that at common law, if you strip away customary rights, that has with it a consequence of compensation. You don't need to compensate here, Tribunal, that we were being told, because we've given you a bundle of rights, given Māori a bundle of rights that is stronger than they would have actually had, so the Crown argued, under the customary rights. But now we've got a Minister saying we've got to reduce those in a spatial extent down to 1 to 5%, where I would have thought that the officials at Tarawhiti might have thought, Minister, you can't do that in terms of ignoring the compensatory consequences of that or the lack of compensation for it. What you could do, potentially, is look at some form of compensation that might offset that step that you're proposing to take, or alternatively, set some criteria. If you're worried about an arbitrary utilisation of that resource consent as being utilised for commercial gain, if that's your concern, but we don't know it is, but if that is your concern, then how about we install some criteria, the same as we've got criteria for the wahitapu. To get a wahitapu order, you've got to be able to establish tikanga and that is in accordance with that, etc. So there's a mechanism for that wahitapu process. Now, it might not have been welcome, and I suspect it wouldn't have been, by Māori claimants that those sort of criteria were advanced, but there could have been discussion with Māori. Is that a possible way around this problem, if a problem existed? Did that sort of exercise, thinking outside the box of the coalition agreement, did that sort of exercise, mental exercise, occur in discussion amongst officials?
It may well have, in discussion amongst officials. Our focus of our advice to the Minister was to clarify the bundle of rights available under CMT, to ensure that he fully understood what those are and the importance of those. That's what we focused on. Through meetings, through briefings, when he asked for further information, that was the focus of our advice.
Thank you, Ms. Marsh.
E hine, kua roa koe e noho ana. Hei papa haukerekere tanga, mā ngā māngai o ngā kaikereme. Ka mutu maupū ana koe, pūmau ana koe ki ngā tikanga, ki te kawa, me ngā mātāpono o tō tūranga kaimahi mā te kawana. Engari, kai te piringi au ki te kōrero kia koe. I nā ia nei, ka huri au ki te reo Pākehā. You've stated that your whakapapa is from Ngāpuhi and Ngāti Porou. I find that very interesting. Really interesting. My question to you is, where did you grow up?
I grew up in Otara. But I was privileged to return ki te wā kāinga in 1990 and spent 3 decades at home.
Which wākāinga are you talking about? In the north?
To the north.
Where?
Yeah, to the north. To the north.
Oh, to the north.
Yeah,
all
to
right.
the north.
Yeah, really, it really doesn't matter which of your whakapapa areas
No,
that
my
you go
sister,
back to?
our sister lives in Ruatoria, so she's got the
okay,
Ngāti Porou
okay.
side covered.
Okay, but how old were you when you went back to the north?
To the north, I would have been, don't want to tell anyone my age, but I would have been
Yeah.
about 30.
Oh, okay,
30.
okay.
30.
But while you were in
to
Otara...
live, to live.
Ka pai. While you were in Otara, did you have any relationship with the sea? Did you go out and whasek for pipi?
We used to wish that one day we didn't have to go to the beach to collect pippies. You know, we wanted to swim like everybody else, but there wasn't a reality. We went to get kai.
Yes, your whanaunga from Ngāti Porou can't see the fruits of going for a swim. If you go for a swim, you need to come back with a bag of pipi.
My parents were of that generation.
Yes, yes. And what I'm establishing here is that your advice to the Minister would have had that background of knowledge about the sea, about your whakapapa to the sea, to the coast, and to the bounty of Tangaroa. E tika ana?
E tika ana. And there are several others in the core group working on it that have lived experience of that.
Yes. So your advice to the Minister would have had that kind of background. You would have been familiar with the whakatauki of the sea, the whakatauki of the kōura.
I'm very aware of the ancestral links to the moana. Very aware. It's not my lean, but you know, and I have to say, when I hear the claimants that have spoken, particularly Ngāti Wai and the ones from the north, I know those people, I know their connection, I know that it's the essence of who they are as a people.
Ka pai, thank you. Are you familiar with the whakatauki of the kina?
No. Ka hore.
Oh, maybe you can have
Our research?
An audience with me, and I'll tell you.
Right.
No. But the Māori whakatauki is, ko te kina te koha a tangaroa ki te tangata. And that can be translated in the way that it's given, but other people have given a twist to it. And it would be a good, one of those interpretations would be something that good, that you can rely on to guide yourself and to look after yourself. Nō reira, tēnā koe, that's all I wanted to know.
So thank you, Ms. Marsh. That completes the questions that we have for you. No doubt Mr. Stevens has some re-examination, but again, I want to acknowledge you for your answers. Tēnā koe.
Tēnā koe, sir. Thank you. And not a huge amount of re-examination, but there are just a couple of things I thought that I would work through. First of all, I just wanted to ensure that there is clarity around the A3 document that has been the subject of questions. And so there are two A3 documents, as we know. The first one, in terms of where it is located in the bundle, is at page 27.
No.
Yeah, not that one. We'll come to that one.
It's not. Oh.
So could Ms. Marsh be taken to the Crown Common Bundle?
Yes.
So this is the A3 that you've been taken to that has the Minister's handwriting at the bottom. And this morning, the Crown has filed a version of this document that takes out the pagination in the bottom right-hand corner, so that the words aren't obscured. And the tribunal should have a copy of that now. That's been distributed to everybody. Can Ms. Marsh be shown that? So that's the same document, am I right, as the document that you have at page 27 of the bundle?
It appears so. Oh, yes.
And so if you look at the bottom right-hand corner, those were the words that were that are obscured in the other version that's in the common bundle. And we can now read the Minister's handwriting.
You might be.
So are you able to make out the Minister's handwriting there?
What happens in Coast?
Yeah. What happens in or on Coast?
Sorry?
What happens, that word is hard to see, in or on Coast?
It's not how I'm seeing it, but I'll take your word for that.
Oh, well, don't take my word for it. We'll just have to interpret the Minister's handwriting as best we can. So that is, anyway, the word is not obscured by the, in this version, the word is not obscured by the document ID. And then, so there's a second document that's similar, and that is at page 529 and 530 of the Common Bundle. So have you got that in front of you?
I have.
Now the document at page 27,
Yes.
if you leaf back to the beginning of this section of the bundle at page 15, it appears from the aid memoir that the document at page 27 forms part of the aid memoir. Is that right?
That it was attached to?
Yes, that's my question.
Yes.
And why is it attached to the aid memoir?
So it's attached to the draft letters that never went,
Mm-hmm.
and to assist the Minister with his discussion with his colleagues.
So looking at the bottom of page 15, can I just ask you to read paragraph 4?
The attached letters, Appendix 1, are addressed to the Prime Minister, Deputy Prime Minister, Associate Minister of Justice, Treaty Principles Bill, and Minister for Māori Crown Relations, Te Arawhiti. The letters note your intention to progress a legislative amendment that will clarify Parliament's original intent regarding Section 58.
Just over the page, yeah, at B.
Attached the A3 that summarises Parliament's intent, the working problem definition and objective of the intended Section 58 amendment, preliminary options and other key considerations that will be addressed as part of the further policy work required to present final options for ministerial decision.
And I can just stop you there, and then if you leaf forward a couple of pages to page 19 and following. These are the draft letters, presumably.
They were the draft letters.
And then, so the document at page 27.
Yes.
That's what you've just referred to, is it? As the A3 that's attached to the draft letters.
To the draft letters that never went.
That never went. In this aid memoir, we can see the date is the 29th of February 2024 at the
Yes.
top. Yeah. So it's at page 27. This is the document which the Minister has annotated with his own handwriting at the bottom.
Yes.
Then when we look at page 529 and 530, that is we can see optically that's a similar document. Can you tell me what that document is and what its purpose served?
This precedes the draft letter discussion. This was the basis of which we were attempting to get the Minister's direction as to the next set of advice. This is where we were asking for him to make some decisions so that he could discuss his proposed approach, scope, timing with his coalition partners and the Prime Minister.
So what did you do with this document, the one at 52930?
This was the basis of the meeting on the 30th of January, I think, remembering, 30th of January. This was the discussion at officials.
So that meeting on the 30th of January, who was at that meeting?
Myself, Nicole Butler, who's the principal advisor, who took the minister through the A3. I recall Lil being there. I think our chief legal advisor, Matthew Andrews, and I think I recall our deputy chief executive, but I'm not sure, Warren of Strategy and Policy, Warren Fraser, given it was across Te Arawhiti kaupapa.
And that meeting was with the minister?
It was with the minister.
And so you're saying that the A3 on 529, 530 was presented at that meeting?
It was the basis of our... He had it before the meeting. You very rare to just table things on the day.
I see. It was sent to him at some point prior to the 30th.
Prior to the meeting.
And then so everybody had it at the meeting and there was a discussion about its contents?
Everybody had it, and there was quite a fulsome discussion on its contents.
So I just want to take you now to your affidavit. And this is, could you turn to paragraph 59? So we can read there that you've said, on 30 January 2024, the Minister met with Te Arawhiti officials to discuss the approach and timing for progressing a legislative amendment, including consultation with Māori. At the meeting, officials presented the Minister with a document that summarised Parliament's intent, the working problem definition and the objective of the intended Section 58 amendment, preliminary options and other key considerations that would be addressed as part of the further policy work required to present final options for ministerial decision. And then there's a definition summary document, and there is a footnote, and you say there, this letter is attached to letters to the Prime Minister, etc. and so forth, the aid memoir of 29...
That's incorrect.
That's incorrect?
It's incorrect.
So,
absolutely incorrect.
Yeah. So would you like to give us the correct version? Would you like to, how do I put this? Would you like to amend your evidence in that regard and explain?
Yes, I would.
Could you do so?
What do you want me to explain? Sorry, you'll have to help me with this.
Sure. So what I want you to explain is, you've just said that the footnote is incorrect in terms of describing the summary document.
Yeah. I recall this so vividly because this was the beginning of the discussion, and I'm absolutely 100% sure this is the document that we used for that discussion. We laboured over it. It went through several iterations, so I'm absolutely sure that this is the document that was discussed on the 30th of January.
So when you say this document, which one are you referring to?
What's the attachment? The one at 5:30, is that? 5:29 and 5:30.
Right, not the one at 27.
Not the one at 27.
So you are saying that your evidence should be changed in that regard?
I am.
Right. What is it? So when we turn to 5:29, 5:30. At the bottom, can you see the red boxes?
Yes.
Can you explain what the function of the boxes are?
To seek the Minister's direction so that we can provide him with further advice that will help to inform his discussion with his colleagues.
So they are to indicate the direction that officials want from the Minister in relation to the questions identified in the box?
In relation to the scope, the potential timeframes, the intent, what the problem is that we're trying to solve, what is the objective of any amendment, what are the options available, and noting this is a discussion document, what are the other key considerations and next steps.
And so, were these all discussed at the 30 January meeting?
They were.
Thank you. I think that clarifies things in terms of the two documents, the two A3s. Next question came out of questions from my friend Ms. Cole. It's a short question. She asked you whether the Minister got the LDAC advice of 10 May 2024. And so that advice, the LDAC advice, that is at page 49. Have you got that in front of you?
I have.
And so Ms. Cole's question for you was, did the Minister get that advice? Could you just turn to page 129 of the Common Bundle? Well, let's start with 128. So that is a briefing for the Minister dated 27 May 2024.
It is.
And then over the page, there's a section, the very first heading is purpose. Well, under further advice on options for section 58 of the Marine and Coastal Area Takutai Moana Act. Do you see the section that says purpose?
Yes.
And paragraph 1 states the decisions on which policy options or decisions on policy options are sought. And then at paragraph 2, could you just read that to us?
The Crown Law Office is Crown Law, Appendix 3, and the Legislation Design and Advisory Committee, LDAC, Appendix 4. Advice on these and related issues are attached and considered in this paper.
And then if we just leaf forward to page 165, well, first we can see a lot of redacted pages starting at 146 that follow immediately after Appendix 2. And then we have LDAC's advice.
Yeah. Yes,
Page
sorry.
165.
Yes.
And that's the same letter.
It's the same letter.
Yeah. Another question that Ms. Cole asked you.
Sorry, Mr. Stevens, just before you move on to the next point, I had raised if you would clarify that paragraph 28 reference.
Yes, and I do have an
which document that was referred
Yes,
to.
indeed. So the draft cabinet paper that is referring to is CB 79. Well, the document starts at page 73. So that's an aide memoir of 18 April 2024. and it provides the first iteration of the cabinet paper. And then that is, that starts, well, very shortly afterwards.
The reference to the paragraph 28 is the one that is the paragraph 28 at page 79.
Yes, yes, that's right.
Thank you.
That's what LDAC's referring to, yes. The paragraph 28. And leafing back a couple of pages, page 76 is where the the first draft of the cabinet paper starts. So that is what LDAC is referring to. So a further question asked by my friend Ms Cole was, did the Minister ever identify what the risk was of doing nothing? And your answer to that was, as I said, he said in the cabinet paper that he considered the risks, but the risk of doing nothing outweighed that. And then, sorry, that was an answer. And then Ms Cole asked, well, what was the risk of doing nothing? That Māori would have their customary rights and interests recognised under the existing legislation. That was a risk. And then your answer was, I think he outlines in the paper the thinking behind that. So can I just ask you to turn to page 458? Well, actually, I'm sorry, that is the one that went to ECO. So let's use the one at page 507, I'm sorry. So as I say, the question was, what was the risk of doing nothing? And your answer was, I think he outlines that in the paper, the thinking behind that. Could you just look at paragraph 72? And could you read the first two sentences?
The risks associated with the proposals are noted above, but these have to be considered alongside the consequences of doing nothing.
And then in the following paragraphs underneath, is this what you had in mind in terms of the Minister outlining his thinking around what the risk is of doing nothing? Could you just have a read of those paragraphs?
Large and or out loud?
Oh, sorry, no, not out loud, to yourself, sorry. Won't make you do that.
That is what he's saying is the risk in this paper.
In his view?
In his view.
Yeah. And that's what you had in mind when you said, am I right about that? That's what he had in mind. That's what you had in mind when you said he
outlines the risks. Yep.
In the paper.
And the reason why the amendments.
This leads into another question that you've been asked, I think, by a few, by council and also I think the tribunal, is about the difference between Te Arawhiti's assessment of Parliament's intent in 2011 and the Minister's intent. The Minister's view of Parliament's intent in 2011. And I think you were saying that they differ. Is that right?
Our view is, despite the Minister's view, that our review of the records point to it being less restricted than his view.
What was the Minister's view of Parliament's original intent based on?
As I said, he was in conversations he had at around the time when the legislation was being discussed. And those would have, just discussions he had. He didn't point to any other sources that I recall.
So the sources are his recollection of discussions that he had with colleagues?
Would have been discussions he had, what he'd read, what was informing his view at that time.
When he was a Member of Parliament,
Yeah.
looking at the Act?
Discussing. It was definitely
bill.
around discussion.
Okay.
Your Honour, I'm sure that you're taking note of the fact that this is all almost triple hearsay.
Well, what I'm asking...
What she thinks the Minister's view was from back then.
Well, the Minister has expressed his view of the original intent of Parliament to Ms Marsh, and she is describing what he stated his view was based on.
Well,
Did he, are those, so the Minister, did he describe to you the nature of what he thought Parliament's intent was in relation to enacting the 2011 Act?
It is
You'll just need to turn that on.
Oh, sorry. It's consistent with in the first briefing where the Minister has underlined the words in the paragraph. It's clear the intent.
Sorry, so let's go to that. So that's the first, that's the briefing of 21 December 2023?
It is. Page 3.
And the handwriting you're referring to is on page 3 next to the top paragraph?
It is.
And then did the Minister...
Sorry, Mr Stevens, what was the page reference?
Oh, it's page 3. So my question was, are those the words that you were referring to just now? Where you said the Minister's handwriting was, the intent is clear?
No, what would be fair is that's the sentiment he expressed verbally.
To you?
To the officials, yes.
And then the question that I was asking is, what was the Minister's view based on? Did he explain that to you?
Based on his experience at the time when the legislation was being discussed.
That's what he explained to you was...
That's what he explained to us.
Yeah. So, I wanted to... So one question that's been asked of you by several people is the principle of equal citizenship and how that doesn't feature in officials' advice. So actually the most helpful place to go, I think, is the cross-examination bundle of Tamaki Legal. So at page 43, using the red numbers.
It's not that one.
Well, yes, 43.
The bundles become, the bundles become mixed up.
Oh, okay, so it's
okay.
hard to find?
Yeah.
Do you want me to find it? It's the coalition agreement.
Oh,
Do you want to hand it to me?
I mean, it's all mixed up.
Oh, right. Do you have it electronically, Zoe?
Yeah, I'll find one.
Oh, thank you. Thanks. So you can see there that this is the coalition agreement between the National Party and the New Zealand First Party. And if we scroll through to page 52. That's 52 of the red numbers. So could you just... So this, you'll see the heading equal citizenship. A series of bullets. And then a series of hollow bullets. And 1, 2, 3, 4, 5, 6 down.
Excuse me.
We just need a break, sir, if that's okay. You all right? Oh, okay, right.
Would it be helpful, Mr. Stevens, if we adjourn for 5 minutes or so? Okay.
Sir, before we do, and I'm loath to do this, so I hope that you feel that, I just want to be very clear, and perhaps I'll just talk to my friend over the break. My understanding of the evidence that Ms. Marsh just gave about the conversations that the Minister had when he was an MP at the time of the passage of the 2011 Act, the current Minister, Mr. Goldsmith, was elected to Parliament in November 2011, prior to the MACA Act, well, sorry, just after the MACA Act passing. So I mean, it might be that she meant something else, but I just wonder whether, I don't want that left hanging. I don't want us to weirdly address it in closing, so I just wanted to raise it with you, something for him to perhaps address.
It would be helpful to get some clarification around that, Mr. Stevens. But with that, we will adjourn for a micro break and we'll reconvene.
So just before we go to the question I was going to ask about equal citizenship, in the break, my friend Mr. Mizu in Easthope has pointed out that the Minister was not an MP at the time of the passage of the bill, and I had put that, I had asked about the discussions that the Minister had relayed to officials at the time of the passage of the bill, and it was me that had suggested, did he have those discussions when he was an MP? So I do just want to go back and clarify with Ms. Marsh about the nature of the discussions that the Minister relayed to her as the source of his view about Parliament's original intent. And so, Ms. Marsh, the question is, can you describe when the Minister was relaying his view of Parliament's original intent, what he referred to as the basis for his belief about Parliament's intent?
Discussions he had at the time, and his experience, his experience at the time. I could read into that what he'd read, what he talked about, but I won't.
And when you say at the time, what do you mean by that?
At the time that the bill, that the legislation was being discussed, developed.
I see. Thank you. I think that with the clarification that I've given, that adequately deals with the point. Thank you. My last question, you'll be very pleased to know, relates to a question from Mr. Crosby on the tribunal. He asked about the seafood industry concerns. Could you just go to page 92? So this is an aid memoir prepared by officials in advance of the seafood industry representatives, in advance of that meeting on the 21st of May.
It is.
And then if you leaf forward to page 98.
Yes.
Can you just describe briefly what this is?
This is the letter to the Minister outlining their concerns.
So, and it's from?
The New Zealand Rock Lobster Industry Council and Seafood New Zealand and the Power Industry Council. On the letterhead, sorry, I need to check the end. Yes.
And what is it that the seafood industry are saying in the letter is their concern? Why did they want the meeting with the Minister?
To raise their concerns about the public consultation process for third parties, for non-applicant third parties. Oh, sorry. For non-applicant third parties, for third parties like themselves.
The public consultation process in relation to what?
In the Crown engagement, which they refer to as the direct negotiation pathway, in the Crown engagement pathway, and my understanding is their concerns were in the High Court process they get to test the evidence. It is not so in the Crown engagement pathway. They get to submit through the public consultation process, and that's taken into consideration.
Thank you. Those are all my questions, sir. I want to also express my appreciation to Ms. Marsh for giving evidence on behalf of the Crown in this process, which has been a significant process for her.
Tēnā koutou. Sorry.
I was just going to echo once again, Ms Marsh, our gratitude for your evidence and for the answers you have provided. It has been most helpful to us to understand the Crown position in this inquiry.
Tēnā koe.
Tēnā koe.
Tēnā koutou. Toro mai tō ringa kia hariru, tia tō ringa iawhi pono, iawhi taku tinana. Oe, 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 oe te aroha ki a rātou mā. Oe, oe te aroha nau whakaroto nei. Hiki tia i ngā iwi, ia rewa ki runga, ngā taonga, ngā matua kua ngaro i te pō. Oe, oe. Oe, oe te aroha ki a rātou mā. Oe, oe te aroha nau whakaroto nei. Tēnā koutou.
Mr Lam.
Kia ora, sir. We have two steps remaining. We have the evidence of Ms Kahukori Baker, and then we have the brief closing statements. I do wonder, we've got some setup that needs to be done, whether we might break for lunch, a shortened lunch break now and then come back, or whether Your Honour is minded to push on through to the end without taking the lunch break. I'm in your hands on that matter.
Is there any prospect of hearing Ms Baker's evidence and then adjourning for lunch to then hear the closing statements after lunch?
I'm entirely comfortable with that. We'll just need to take a few moments to have the lectern set up. And
okay, perhaps we should take another micro break while you do that, and then we can reconvene.
As Your Honour pleases. Tēnā koe, sir. So for Y1092, 1758, 1787 claims on behalf of Te Pukarihi Iwi, I call Kahu Kori Baker to the stand. Your Honour, Ms Baker has prepared 2 briefs of evidence or affidavits for this inquiry, and these are recorded as Y1092B1, which is dated 6th of June, and I don't understand that's made its way to the Y3400 record of inquiry. And then there's a further affidavit dated the 7th of August, which is A10 on the record of inquiry. That A10 affidavit has yet to be sworn for a range of reasons, but we will undertake to have that done while we have a room full of lawyers and have that filed on the record of inquiry, Your Honour. Kia ora, Ms Baker. Thank you for making yourself available, and I understand there's been some difficult circumstances which prevented you from presenting earlier. You've just heard me list your evidence, and could I just confirm that you do have access to those briefs of evidence here today?
Yes, I've got access to the second one. The first one I don't have with me.
Ka pai. Well, we may need to bring that up if there are questions on it. And could you confirm that your full name is Kahu Kori Baker?
Yes.
And you are a senior analyst based here in Wellington?
As of last week.
Ka pai. We won't dig. And could you confirm for the record that your evidence remains true and correct as of today's date?
Yes, it does.
Ka pai. Now, how we'll attack things today is, I understand you'd like to make a short mihi or introductory statements, and then we'll pass to my learned friend for the Crown, who has some questions for you. The Tribunal may also have some questions for you, and then it'll come back to me if I have any questions arising. Ka pai.
Kia ora.
So I'll pass the time to you, Ms Baker.
He mihi tuatahi ki te atua. Tuarua, papatua nukui waho te whare e tū nei. Tēnā kōrua, tēnā kōrua. E nā rangatira o te tarapairu e te tarai piunara. It's funny, anglicising, Māoriising English words. Tēnā koutou. E nā roia, e nā iwi o te motu i tēnei ata, i tēnei wā, tēnā koutou katoa. Ko Waiahau, ko Kahu Kori Baker, tōku ingoa, ko te upukarehi me te whakatohia o ku iwi. When we gave evidence, when upukarehi gave evidence at the Stage 2 hearing, we made it very clear that the MACA Act was not something we supported. We found it very difficult to work our way through. Our kaumātua spent a lot of time talking about the difficulties and the lack of trust in entering into a process where we had no idea what the outcome was going to be, and where a lot of our wahi tapu had to be put openly before the courts, where our way of life and our living as a people were before the courts to be examined by a third party to then make their rulings on. However, we entered into the process despite the difficulties. In fact, you'll find Te Upukarehi and enter into whatever process we can to fight for our taku taimoana and our whenua, no matter how hard the process or how bad it is. So we entered into it knowing we had difficulties with it. Yes, we did secure customary marine title and protective customary rights and wahi tapu protections. We appealed some of that in the Court of Appeal. We're also heading to the Supreme Court. And then this comes along. So we've put a lot of work into the process, and then we strike this. And what do we find? We're being asked to take on trust that the work we have done so far is going to stand as it is. We're being asked to take on trust that all the work we have done, the titles we have secured, will hold. How can we? How can we possibly take anything on trust? How can Upukarehi ever take anything on trust from the Crown? We've got over 160 years of betrayal upon betrayal upon betrayal, one upon the other upon the other. You cannot take away that past and just look at the impacts of today in this Act as if they don't relate to the past we have already trod. We've just come out of the whakatohia settlement where we had the Crown presenting our whakapapa back to our kaumātua on the understanding they thought they knew that better than our kaumātua. We appealed that process. We should have been taken out of it. Over 60% of Te Pukerehi wanted to come out, but the Crown could determine whether it would take us out or not. So all the way through, we're being asked to rely on what the Crown says it's going to do. So we're being asked to do that again, and I think some of the kōrero from our kaumātua in their briefs sum that up very clearly. We have my co-claimants, kaumātua Wallace Aramoana, Maud Edwards and Christine Martin. They've talked about how this is nothing but a continued abusive process through structural violence, through normalising abuse and inequalities through law and policy. My kaumātua says, all this mahi we are doing for our mokopuna and the ones yet born, but the continued abuse from the Crown signals to us they want to keep us oppressed. It seems like they are throwing a stumbling block in front of us no matter which way we go. My memory goes back to a time when my tipuna spoke about the same oppression that my grandparents and other tipuna went through. I'm wondering, is there ever going to be an end? The government seems to be pressing down on us again. We are not the only ones being affected. The Crown is damaging treaty relationships across the Māori. And that is a significant issue that we have here. We're being asked to take far too much on trust, and we have no treaty relationship with the Crown. They don't even recognise Upukarehi iwi exists. So we're being asked to take all this on trust, and there doesn't seem to be anybody holding the Crown to account. What happens when you are already in front of the courts, where you have had to trust due process even though you don't like it, and all of a sudden a minister decides that, oh goodness, Māori are getting too much. Now, it's all been very clear over the last couple of days. There are no logical reasons for that. The only reasons I can assert are those that interfere with supposed commercial interests. We've heard this morning there are no real issues there. But clearly somebody feels that Māori are getting too much, so racism is a clear one. And when you do value the treaty, you do value the treaty partner, you're opening the door for massive racism to come forward. There was a Hobson's Pledge ad, and you don't have to look far in social media to see the outpouring of anti-Māori sentiment. And then we get this. So it looks to me like the Crown is very much supporting that. It is enabling that. And on top of that, they've got the private interests they want to curry favour with. Well, that's not new to Upukarehi. That's been happening to us time and time again. So what we are supposed to ask our rangatahi and our tamariki to trust is the rule of law and due process. How can we? The Crown has just shown us all, if they don't like it, they'll reach across and change it. No one is holding the Crown to account here. We thought that, to a certain extent, the courts could. We could go and make challenges to certain things in the court. Well, what the Crown has just shown, not just Upukarehi or Māori, but all New Zealanders, if there is a piece of law going through the courts, in front of the courts, and somebody doesn't like it in the Crown, they will reach in and change it. So where does that leave this country? Where does that leave the treaty partner? Where does that leave the entire constitution and all the jurisprudence that's been built up around the treaty for over 30 to 50 years now, thrown out the door? That's what this is actually doing. It's a lot more than changes to the MACA Act. The way it's been done is absolutely appalling. The Crown needs to be held to account. And that was the main point coming here today, to talk about the issues that our kaumātua have already gone through, to talk about the fact we have to take it on trust our current CMT won't be affected. And you've heard how difficult it is. How can we try and advocate a future with our people when the Crown keeps changing the goalposts again and again and again? It doesn't matter whether it's raupatu, it doesn't matter whether it's direct negotiations, it doesn't matter if it's this. The Crown keeps changing the goalposts, and I think Kaumata was really correct when he said, where is this ever going to end? They're just wanting to keep us oppressed. So that's Stu Pukerehi's take on the settlement. Kia ora.
Kia ora, Ms Baker. If you look to your right, my learned friend there will have some questions for you.
Tēnā koe, Ms Baker. I'm Tim Stevens, one of the counsel for the Crown. I just have a couple of questions. I want to refer you first of all to your brief of evidence that is filed on the 7th of August. It's got the document number A10. Do you have a copy of that?
I do have.
At paragraph 5 of that brief, you say, nothing that I have seen so far justifies the Crown's proposed changes to the MACA Act. Public statements put out by the Crown state that they are clarifying the situation. However, the changes proposed have gaslighted and further muddied the implementation of the Act. Why is it that you say that the changes proposed are gaslighting the Act?
Because the Crown has got the audacity to call it clarification, when it isn't clarifying. It's actually writing a whole new CMT process. That isn't a clarification. If the Crown wanted to clarify, well then surely you would think that the Supreme Court would be allowed to take place and be heard and set precedents.
So it's objection to the use of the term clarification when you say that it's not clarifying Parliament's intent, it is effectively introducing a new, it's introducing something new, is that, and to claim clarification against what you say is the reality, that's the gaslighting?
But it's also changing the concept of customary marine title to something very, very narrow that we weren't aware of when we entered into the entire process. So once again, our concerns and our views around it have been gaslighted, and the process is also a gaslighting process.
Okay. At paragraph 6, you refer to an advertisement that was taken out by Hobson's Pledge, that was on the front page of the New Zealand Herald, which you say is deliberately misleading. Why is it reasonable to say that the Crown is encouraging and facilitating that ad? Which is what your evidence is?
Yes, it is.
And how is that?
By adopting the process it has adopted. Because there is no real concern for the Crown about fisheries interests requiring protection under the Act. There is no real concern that Māori is suddenly going to be far more privileged in this country than anybody else. That is not correct. That ad was an absolute beat-up.
Yes, but not taken out by the Crown or supported or facilitated by the Crown.
I think we all know that when it comes to politics and commercial interests, there is a very fine line, and it seems to be getting finer.
Yes, I guess my question is, in what way, though, do you say that the Crown encouraged or facilitated the ad?
Because by devaluing Māori and devaluing the treaty, you are creating a space to be filled by the people of Hobson's Pledge and others.
Okay. I went back to the joint brief of evidence that you refer to in your affidavit for this inquiry. A joint brief of evidence, it's got, you refer to it in your current affidavit. It was filed in relation to Y2660, and it is document number B39.
Who's it by?
It's a joint brief of evidence from you, Maud Edwards, Richard Wikotu, Trevor Ransfield and Wallace Aramoana.
Yep.
And it's dated the 10th of August 2020. Do you have that handy with you
No,
today?
I don't.
Would we be able to bring that up?
If you give me 1 moment, I can bring it up on my computer.
Oh, thank you very much.
To the witness.
Thanks.
So you've got that in front of you now?
Yes, I do have.
Could you just scroll through to, does everybody else have it, is the other question. So it's B39 and Y2660.
We could send a copy to the registrar if that might help to locate it.
Yes, it should be coming shortly.
Blame the Ministry of Justice IT system.
Perhaps if you just continue, Mr. Stevens, we'll follow as best we can.
You should be able to follow my questions. So, Ms. Baker, could you turn to paragraph 14 of that joint brief of evidence? Have you got that there? I'm just bringing it up. Mm-hmm. And so you can see the heading, Tikanga Māori exclusive use and occupation, and then you set out section 58, and then you say underneath section 58, in this clause 1A, far from being supported by 1B1, is contradictory. As tangata whenua, tuturu and kaitiaki of te upu korehe takutai moana, the iwi determined how, when and who would have access to te upu korehe takutai moana and on what terms. This recognition continues today. And then you go on to say in paragraph 15, consequently, the issue is not one of exclusive use, but of who traditionally held and holds the right to determine the use. This includes whether this was to be extended to neighbouring hapu and iwi, the nature and terms of that use, and what was to be provided in exchange. In other words, those who held mana whenua and mana moana over their own rohe controlled the kai source and therefore controlled the tribal economy. As such, te upu korehe is the legitimate holder of customary title, as opposed to those who had the use of the takutai moana under the mana of upuku korehe. Section 58, customary marine title does not provide for te upu kōrehe as the tangata whenua tuturu in the te rohe of the iwi. As a consequence of the MACA, our very own tu upu kōrehe tanga, sorry for my poor pronunciation of the name of your people, and practices are reinterpreted by this legislation and potentially used against us. So after reading all of that out, is your view of Section 58 then, at that point, one that essentially coincides with the understanding of the section prior to the Court of Appeal's decision in Edwards?
What are you referring to?
Well, you appear to be critical in your evidence here for Y2660.
But when you say coincides to what? What am I looking at?
Well, you are criticising Lim B1, which says, so two limbs. One is holds the specified area in accordance with tikanga, and then B has in relation to the specified area exclusively used and occupied it from 1840 to the present day without substantial interruption. And you seem to be critical there of the incorporation of B1 as B Roman 1 as part of the test for customary title. Is that what you're saying?
Yes.
Would you level the same criticism at the content of the section now we have the Court of Appeal's interpretation of Section 58?
I think we are going to have to go to the Supreme Court over this. So I'll be able to tell you after the Supreme Court hearing when we get referred back.
Yes, and there is going to be a Supreme Court hearing in November in relation to these issues. But my question really is, when you were looking at Section 58 in 2020, what is the criticism that you are making of Section 58B1 in these paragraphs in your evidence? What is it that you're saying that you object to in relation to that limb of the test?
Exclusive use and occupation from 1840 to the present day without substantial interruption.
And what is it that you object to about that? Or what did you object to about that?
Probably the way it can be interpreted, who determines what is exclusive use, who determines whether it is occupied from 1840, and who determines substantial interruption.
Okay.
Because what we've said is...
Go on.
It isn't about exclusive use, it's about who held the mana to determine the use. That doesn't provide for that.
Well, that is in Lim A, holds the specified area in accordance with tikanga. So that's where the question of mana is primarily engaged.
Well, that's why it has to be tested through to the Supreme Court.
Okay. Last question. Talking of the Supreme Court, you say that it's unclear what the effect of a Supreme Court judgment remitting the matter back to the High Court will be. Could you explain your concern there? We
don't know whether it's going to be reheard under what part of the Act. Well, I haven't seen anything that says if we do get referred back, it will be under the old Act instead of the new Act.
Oh, and I see. And that's the matter on which you believe there should be further clarity.
Yes.
Yeah. Okay. Thank you very much, Ms. Baker.
The other thing I should say about that, and I know it's heading into the Stage 2 hearing, is the funding provided for this.
Yeah.
I think my second brief also talked about the real concerns we could be heading to a user pays regime, and we certainly can't afford justice on that basis. We certainly couldn't afford to go to the Supreme Court on a user pays. I don't think we could have enough cake sales and fundraising to get us through the Supreme Court?
Yes, well, and those matters will be engaged on stage 2. Apart from that, those are all my questions. Thank you very much.
Kia ora.
Kia ora. Thank you, sir.
Kia ora, Ms. Baker. Thank you for the evidence you've provided. We don't have questions for you, but we want to acknowledge you for making yourself available today and for your overview and the answers you've provided to the Crown.
Kia ora.
Tēnā koe.
Kia ora. Sir, I don't have any questions of re-examination, but I understand Ms. Baker would like to finish by with a whakatauaki.
Well, it's actually our father's translation of a very well-known whakatauaki. The whakatauaki is, ko te pai tawhiti whaia ki a tata, ko te pai tata whakamaua ki a tina. Now, our dad translated that as, seek ye the distant horizon, the horizon that ever recedes, the horizon that causes dread, for on that path will lie our destiny. Kia ora.
Tēnā koe. Well, that brings us to the lunch break. We are a little bit behind, but I will shorten the lunch break to try and make up for that slightly. So if we reduce the break to 40 minutes, we will adjourn and we'll reconvene at 1:35, and then we should largely be back on track to hear the closing statements. Kia ora koutou. Mrs. Ewani's type.
Tēnā koe te kaiwhakawā o tira tēnā tātou. I te tuatahi me mihi ka tika ki te moana. Ki te moana. Ka hoki ahau a tōna wā ki tētahi atu moana, ara ko tā tātou nei moana nui ākiwa, engari te tuatahi me mihi ka tika ki te moana. Tuarua ki ngā kaikireme, ki konei ngā kaikireme e whakarongo ana tēnā koutou e kore e mutu ngā mihi ki a koutou mō o koutou kōrero, me o koutou whakaputa whakaaro, whakaputa hononga ki tō tātou nei taonga te moana. So following that, I am going to start with some caveats and I'll be brief on those. Just taking a note of the time. This closing statement is intended to assist, it's intended to be brief, it's intended to effectively be the key points and themes that we say are important for your consideration. I am not here for my client alone, standing up with my client portrait on. Of course, that's difficult to take off, but effectively I'm here for, as he waha kōrero, mō tātou katoa. But make the point explicitly, as we do in paragraph 1, that obviously closing submissions are due on Friday and people will take that opportunity to put forward their submissions. But these are the key themes. So at paragraph 2, and I'm sorry, I'll just double check that you have the note. At paragraph 2, we say the MACA Act already breaches te tiriti before these proposed amendments. All claimants and interested parties are united in their view that the Crown has breached te tiriti o Waitangi in the process it has followed and in the proposed substantive amendments to the MACA Act. Radical changes to the MACA Act are being proposed based on a flawed and prejudicial political and philosophical choice. The Crown is being unjust, unconstitutional, and quite frankly dishonest about what it is doing here. And the proposals are targeted at reinforcing Crown hegemony and have already stirred up racism and division. So, me hoki ahau ki te moana nui ākiwa e kua kōrero here. We've started the framing of these key points with a statement from tō tātou nei pāpa Moana Jackson, and we do that for a range of reasons, but I'll just note 2. 1, to remember him and his contribution to this kaupapa in particular, but obviously all of the various kaupapa that he committed himself to, including constitutional transformation. And secondly, related to that point, the wero that he would always lay down for us about, the irony probably doesn't take it so far, but the perils of incrementalism, i.e. participating in a system that is unjust, unfair, and having to do it again and again and again. And as I will come back to, history eerily repeating itself, as he said it does, when one adopts the incrementalism model. So related to that, we say there is an overarching and confronting constitutional issue here that needs to be called out. And part of that is that the Crown is not even playing by its own constitutional rules. No respect for te tiriti obligations in process or substance. We heard from Ms Marsh that the Minister was very clear on the legal and constitutional risks, and notwithstanding those risks, the Minister and Cabinet are continuing to push ahead. We say no respect for separation of powers, and I'm at 3B, rule of law and the Cabinet Manual. And we say that for 3 primary reasons. 1, here we have the Crown seeking to legislate before the Supreme Court can issue a judgment in Edwards, so before the Supreme Court has had an opportunity for the first time to consider this legislation. And therefore we say not allowing a proper constitutional conversation to occur between the branches of government. Secondly, you have here in the Crown evidence a sitting Minister of the Crown calling a member of the judiciary a communist judge in a meeting with seafood industry and the Crown's own officials. I mean, sorry, just saying that out loud, I don't think anyone in this room would have anticipated that is where we would be in 2024 in New Zealand, but here we are. And lastly, on this point, the advice process. Now, accepting Ms Marsh's view that Te Arawhiti gave fulsome advice, including in relation to treaty breaches, but was unclear about whether the evidence is on behalf of Te Arawhiti or the Crown. And we want to be clear the claims are obviously against the Crown, not Te Arawhiti. But the Minister kept moving the goalposts due to his own views that were not grounded in advice, fact or reality. The claimant's position is that large parts of Te Arawhiti's advice was inadequate, particularly at the outset of the process. And we say the evidence reveals the systemic failure of Crown officials to challenge breaches of Te Tiriti and its principles in their advice to ministers, and their difficulty reconciling this Westminster system with Te Tiriti. It is clear from the evidence that free and frank advice means ministers can choose to ignore Te Tiriti, and officials must go along with that, stating the risks of doing so in one sentence and pointing out the minister's prerogative to proceed in the next. And we say there is concerning complicity there. And finally, on the sort of overarching constitutional point, a coalition agreement between two political parties, again, is providing the only frame for advice and next steps. The Crown is more committed to the coalition agreement than it is to Te Tiriti. Because of the coalition agreement, you have a clear case of political reverse engineering, where there is a stated political outcome with no actual policy problem and a backfilling exercise. The second primary point at paragraph 4 is the make clear Parliament's original intent line from the coalition agreement is just simply a farce and a smokescreen for what appears to be the actual intent of this iteration of the Crown, namely to reduce the number and extent of CMTs being awarded to Māori. And so we say intent has been canvassed in the advice from officials to the Minister without scrutiny. And intent is primarily being used to describe two situations here. One, what was in some, or perhaps one, we should say current parliamentarian who was not an MP at the time, what's in his mind at the time that the MACA Act was passed in 2011. So that's sort of the original intent in the coalition agreement. And secondly, the Crown's current intent in the context of the proposals to amend the MACA Act. So the problem that Te Arawhiti tried to solve from at least 21 December 23 in the note, did not take into account the coalition agreement framing of the amendments being required to reverse measures which have eroded the principle of equal citizenship. The Crown's actual intent here, which they are not being explicit about, is far more aligned with the Crown's explicit policy for the Foreshore and Seabed Act. Namely that, and this is a quote from the passage that Your Honour took Ms Marsh to this morning from Ms Smith's evidence previously provided for the Crown, that recognition of only small and discrete areas was a policy consideration that underpinned that Act, i.e. the 2004 Act. So this is not about a balancing of interests, and I'm at 4E. This is about fewer CMTs being awarded than is currently possible and may continue to be possible under the MACA Act. To do so, the Crown proposes rebalancing the MACA Act in favour of commercial interests to the extent where it is not even clear that the unique facts in re tipene would meet the proposed test. Now, that is the only, based on the Crown's own evidence, the only situation where we have a sealed order of the High Court following an award of CMT. And ultimately, we say the Minister has ignored advice on process and substance from all official channels. Te Arawhiti, Ministry of Justice, I said Crown Law there, but we need to be careful about that in terms of acknowledging the privilege redactions that have been made, LDAC and others that we may not know about. The whole way through this process, proposals are being driven by the Minister and seemingly some of his ministerial colleagues. At 5 and on retrospectivity is not required to achieve even what the coalition agreement says. The Crown has its own appeal in Edwards, that's the Supreme Court appeal, so all extant appeals for live cases could be considered on the basis of that Supreme Court judgment. And this is why it is critical that advice needed to be provided on the distinction, to the extent that it wasn't clear to the Minister, on the difference between a High Court saying, I have found these applicants meet the test, and a sealed CMT order. And we say for those that have invested financially and emotionally in progressing applications, retrospectivity in particular comes as a cruel and humiliating twist. Next point is lack of engagement with Māori. The Crown accepts that it did not engage before Cabinet took decisions. The Crown could disclose information to applicants, but it wouldn't or it didn't. And we say if you compare the limited detail provided to those few Crown engagement applicants compared to the information, or should we say free and frank exchange, the ministers had with the seafood industry, it's clear that there was information being shared, but it certainly wasn't with applicants under the Act. Next is a point about international obligations, and we are just not clear on what advice was provided to the Minister on international obligations, picking up on the point my friend Ms Sykes raised this morning. We don't have a defensible reason in our submission to explain the haste. Only inferences can be drawn, and I put one inference to my friend, Ms Marsh, whanaunga, that one inference to be drawn is that the Crown is attempting to pass legislation before the Supreme Court has a chance to issue a judgment. Another inference which I think can be drawn, which comes up about the exchange that I had and perhaps some of the questions from the panel, is that there is a concern somewhere that there will be limiting of fishing interests, limiting of the opportunities for aquaculture development, such that there could be a rush of applications that are made. And because an application has been made, CMT doesn't trigger in terms of the veto right. So we just don't know because we don't have that information, and we say that the tribunal can draw its own inferences based on the material that it has before it. And finally, in terms of prejudice, the Crown acknowledges no consultation but continues to maintain that prejudice is unclear or premature, not that there will be no prejudice. Uncertainty itself is prejudicial, particularly in the situation that we have here, where you have applicant groups before the High Court, literally today, in one instance. That in and of itself is prejudicial. And we say every time the Crown actively ignores its obligations under Te Tiriti is prejudicial. And so if the amendments that are proposed are passed, clear prejudice will occur based on the claimant, interested party and Crown's own evidence. And finally, coming back to partly where we started, history is just blatantly repeating itself here. We are 20 years to the year after the Foreshore and Seabed Act. Claimants are back before the tribunal, showing their connection to the takutai moana, fighting for their rights as they had to do in that prior context, and then again now. And it is a eerily similar script, and seemingly now even more so than before this morning, potentially, when the ink dried on this document, as we have explored the actual intent, or what the actual intent might be vis-a-vis those policy intentions that underlied the Foreshore and Seabed Act. And so again, we say it is open to the tribunal to draw a range of negative inferences based on the evidence or lack thereof, included the stated make clear Parliament's original intent being not the objective at all, but rather the Crown intending to limit the number and extent of CMTs that can be granted under the MACA Act. And one of my friends reminded me that Minister Goldsmith, was on the news last night quoting the 5% number that appeared, at least in part of the minutes that we have seen with the seafood industry meeting. And so ultimately at paragraph 12, and we do not obviously in this time run through all of the different findings that the claimants are requesting in their own claims, but fundamentally the claimants and interested parties are seeking a recommendation that the Crown urgently halt its proposals to amend the MACA Act. So that is the closing statement, and obviously I can answer questions, but I'm also mindful of the role that I am playing, so I need to be careful in that.
Just one question, if I can.
Sorry, yes, Mr. Crosby.
Can I take you to your paragraph 4B? And you used the phrase, what was in some, or perhaps one, and you inserted the word current parliamentarian's mind.
Yes.
Who are the some that you're referring to?
Well, I think that's a good point. I mean, you had, I think, at that time, although why I amended it on my feet was obviously because it's coming through that clearly it was the current minister's intention that's driving this. But you did have Minister Finlayson before the tribunal giving his views prior to that, but other than that, we don't have any other evidence.
But for this current proposal, it seems to have emanated from one, you say current parliamentarian, but non-parliamentarian views as to what was intended back in 2010.
Yes, yes, and obviously
and then those views being put in a cabinet paper, which cabinet has then agreed with.
Oh yes, it's definitely a decision of the Crown and Cabinet. I'm not suggesting that they absolve themselves of any responsibility, but we are focused on Minister Goldsmith. But perhaps if I can take the points slightly further, is that the only evidence that you have of those sort of ministerial feedback loops are with primarily ministers that are in the New Zealand First Party.
But the focus, and it would appear that the only concentration on the intent, or the so-called original intent, seems to stem from Minister Goldsmith.
Yes, I would agree with that, in the sense that Minister Goldsmith has been saying to officials that this is the intent, and that is, as we've heard this morning and yesterday, based on his discussions at the time, his discussions at a time where he was not a Member of Parliament.
Right. Thank you.
Kia ora Masuini Slope. I don't have any questions for you, but I do want to commend you and all of Claimant Council for their very helpful closing statement and the collaboration that has taken place to produce a short and succinct overarching statement hitting those points. It's very helpful for us, so thank you, and we look forward to the more detailed closing submissions. Tēnā koe.
Tēnā koe, Your Honour, tēnā tātou.
Ki te reo Māori e karangane, whakarongo ki ngā akoranga tira, Mr. Stevens.
Thank you, sir, and tēnā koe. The Crown will obviously address the issues that arise in the inquiry and its written closing submissions, and our focus will be there in terms of working through the matters that arise in the inquiry and what's been traversed over the last few days. So I only intend to say something very brief. The first is something on the issues, and there are essentially two key issues. One is the proposed amendments to the Act themselves and whether those amendments are consistent with the principles of the treaty. And as I said in opening, the Crown submission in stage 2 of Y2660 was that the regime as understood prior to October 2023 in the Court of Appeal's decision, the Crown submission was that the legislative regime involves a reasonable and treaty-consistent balancing of the customary interests that Māori have in takutai moana with the many other intersecting interests that now exist in takutai moana. The Crown acknowledges, of course, that the Tribunal took a different view in Y2660, as did the claimants, as will the claimants, and the Tribunal no doubt continue to do so. The Crown will advocate for its understanding of the legislation as currently enacted in the Supreme Court in Edwards, on the basis that the Crown maintains the view that its interpretation of the current Act is a reasonable and treaty-consistent view. In the meantime, the Crown proposes to introduce legislation of general effect, which it is suggested broadly aligns at least with that for which it will advocate in the Supreme Court in Edwards, and that, of course, is to acknowledge Your Honour's point made to me in opening that where matters ended up, the Minister was concerned to go beyond the initial point about the Court of Appeal's decision in Edwards and address High Court cases, and in particular the interpretation of the High Court in Edwards as well. But all of that is still to say that the position that the Crown proposes to advocate for in the Supreme Court broadly aligns with the proposed amendments to the Act. So the first issue is the treaty consistency of the proposed amendments. The second issue is the process by which, the process that the Crown has followed in development and implementation of the proposed amendments. And it is apparent from the Cabinet paper and other briefing documents that officials, LDAC and Crown Law have provided advice on the process to the Minister, and the Minister, and that advice, or at least the nature of that advice, has also been put before his Cabinet colleagues when Cabinet has made a decision. It was suggested at one point during questioning of Ms Marsh that the Minister didn't accept advice at all. But in my submission, that's not correct. And if one goes to the evidence of Ms Marsh at paragraph 103 of her affidavit, it's clear there that the Minister initially intended or initially proposed to apply the proposed amendments to Section 58 retrospectively. And as I say, it's paragraph 103 of Ms Marsh's affidavit. The Minister also indicated his intention to apply the proposed amendments to Section 58 retrospectively so that CMT awards that had already been granted would be reconsidered under the restored new test. Ultimately, there was advice on that from officials, LDAC, Crown Law, and that is not the approach that was ultimately adopted by Cabinet or recommended to Cabinet by the Minister, and instead a different approach to retrospectivity has been taken. So that does reflect the Minister taking advice and acting upon it to some extent. What drives the question of retrospectivity is apparent in the Cabinet paper, and that is if there is legislative change, then it will potentially, depending on what the Supreme Court does in Edwards, mean that CMT and Aotearoa will have been arrived at on different bases. And so it's a desire to minimise the number of differential awards based on two different tests, potentially, that drives the idea of retrospectivity. And that obviously runs into what has been described in the advice as well-established norms and constitutional conventions about legislation with retrospective effect. And that is addressed in the Cabinet paper at page 508 of the Common Bundle from paragraph 77 and following. And the Minister starts off by saying that any option of legislation will have a retrospective element because even declaratory statements about Edwards that overturn the reasoning of the courts will apply to applications that haven't been heard yet but were filed before 2017, the 2017 cut-off on the basis of the original test wording. And so retrospectivity of some nature is inevitable if these amendments are to be put in place because all applications have been made in 2017. The Minister goes on to say, squarely, prospectivity is one of the strongest underlying presumptions in the common law, and the Legislation Act 2019 itself contains that presumption. Paragraph 79, he goes on to record, parliamentary sovereignty means that Parliament can pass retrospective laws, but there are strong constitutional conventions that influence the use of retrospectivity. It's only used where necessary and with good policy reason. This expectation is heightened when retrospectivity is used to deprive litigants of the fruits of their litigation, in this case, awards of CMT. The Court of Appeal has described retrospectivity in similar circumstances as draconian. And then the Minister sets out the four predominant options in paragraph 80. At paragraph 83, he says retrospective application of Section 58 amendments could be made to all applications past and future so that all cases are decided on the same test. This avoids differential treatment for applications based on when cases were heard and determined by the courts. He then says at paragraph 84, nonetheless, the fairness of applying the same test to all applications needs to be considered in light of the unfairness of depriving litigants of their already awarded CMT. And then there are redactions for legal privilege. He talks about the complexity of retrospective application of an amended test. He says at paragraph 88, a prospective approach allows litigants to retain the fruits of their litigation at the cost of potential inconsistency between earlier and later CMT awards. Within a prospective approach, there is a decision between applying the restored test to cases that are currently in progress. Paragraphs 81 through 4 outline the options for having live cases at the time of announcement continue under the Court of Appeal interpretation or reheard under the restored test, respectively. The latter option, which is the one that is adopted, causes more disruption and costly hearings for those live cases, but removes any incentive for cases pending judgments to rush to decisions so that they can be made on the basis of the Court of Appeal's test interpretation. And so that's the rationale that the Minister has for the approach to retrospectivity that is taken. It's a concern about the incentive for cases which are pending judgments, for those cases to involve a rush to judicial decisions so that they can be made on the basis of the Court of Appeal's Edwards interpretation, and retrospectivity by reference to the date of announcement. The Minister's approach is to avoid the creation of that incentive, and so that's why it is the date of the Pānui, 25 July, and not the date of enactment of any act. So as I say, we will set this out for the tribunal in our written closings, but that is the explanation from the Minister in his Cabinet paper for why he has recommended to Cabinet that the retrospectivity approach taken is justifiable in his view. On process, I also want to refer again to the advice that the Minister has received, and that he records in his Cabinet paper when speaking to his Cabinet colleagues. Advice of the Attorney-General to Ministers that good law-making processes must be adhered to as much as practicable, such as allowing sufficient time for select committee. Advice from Crown Law, the Ministry of Justice and LDAC supports this. Officials further advise that a non-standard process in the present circumstances dealing with such important property rights as customary title to the common marine and coastal area is likely to be inconsistent with the principles of the Treaty of Waitangi. So the advice that the Minister has received is set out squarely in that paragraph for the benefit of his Cabinet colleagues. The Crown has acknowledged in its opening submissions that there was no consultation with Māori prior to the 25th of July, and we engaged on that proposition in opening. I also want to raise briefly a concern that has come out in some questions from my learned friends and generally about whether the Crown is treating this inquiry as a substitute or a meaningful substitute for the consultation process. And I want to be clear that of course it's not. It's not a substitute for a treaty-compliant consultation process in the manner recommended by the tribunal. Nonetheless, it is important from the Crown's perspective to say that the tribunal's report and what claimants have said to the tribunal is a matter of importance for the Crown, and what has been said here, as well as the tribunal's report, will be relayed to the Minister as part of the ongoing process to advise in relation to these proposed amendments. So I do want to be clear that the nature of my questions, for example, are not intended to be any kind of substitute for meaningful consultation, meaningful and fulsome consultation that was referred to by Ms. Marsh. But the Crown or Crown officials do nonetheless consider it valuable to hear claimants in the course of this process and to assure claimants that they are being heard by those who represent the Crown in this inquiry. So I did just want to make that clear. Other than that, I do want to acknowledge claimants again and the tribunal and claimant counsel for the way in which this inquiry has been brought to hearing. I'm very grateful to them and wish to acknowledge you all. Tēnā tātou.
Kia ora. Thank you, Mr. Stevens, and thank you for that helpful summary. I do just have a couple of questions for you, and I'm happy for you to either answer those now or to consider them further in the written closing submission. And you have already acknowledged this in part, but I'm just struggling a little bit with one of the Crown arguments. And in particular, you have confirmed again in your closing statement that the Crown position is that the Act provided a reasonable balance between Māori rights and interests and the public's rights and interests prior to the Court of Appeal decision. If, and I raised this with you as you mentioned in openings, if the amendments were only seeking to overturn the Court of Appeal and to reinstate the High Court decision, then the amendments would be consistent with that position. The amendments, though, go further and seek to overturn the High Court, and either the amendments are not consistent with that position, or the Crown is saying that prior to the Court of Appeal decision there was an unreasonable balance in favour of Māori. And I'm struggling because the two positions don't seem to be consistent. Either the Crown doesn't consider it was balanced beforehand, or it's saying it was balanced and is taking the amendments behind that or beyond that anyway. And I'm just unclear about really what the Crown's position is there. So I invite your comment now, or that's something you may want to consider.
It is something that I want to consider. I think it is better that I reflect on that. I certainly understand Your Honour's point, and that point that Your Honour has made is properly addressed in our written closing, and I'll ensure that we do that.
The other matter that I was just wanting to raise is the question of the absence of evidence. And as you're aware, evidence has been raised heavily through both the interlocutory phase and then also through the course of this hearing. And I'm not going to raise all of the instances, but there were some of the points that I raised, in particular with Ms. Marsh this morning. So firstly, around parliamentary intent. And it seems now that we're being told that that has come from the Minister's view that he formed through conversations with people we don't know who or what the content of those conversations were at the time the Act was passed, when he wasn't an MP. No further evidence about what that means. We don't have any evidence about what the Minister was relying on about New Zealanders' expectations around the Act. Again, that seems to be another key policy rationale. We don't have any evidence about the public interest or the public right that needs to be protected by these amendments that is not already protected under the Act. Again, that appears to be a key policy rationale. And finally, we don't have any evidence about the Minister weighing up the Māori interest in terms of undertaking a proper balancing exercise. So those are not all of the cases of an absence of evidence, but those were some that I canvassed with Ms. Marsh this morning. So I'm certainly interested in your view on how we should treat the absence of evidence, particularly on some of the key issues underpinning this policy and these amendments.
Yes. So again, I certainly understand the issue. So with the hand-up that I provided with my opening, that contains, I think, should be reasonably comprehensive in terms of what is there in the documentary record about the advice to the Minister about Parliament's original intent, and then the Minister's own view.
Yes, well, I'm fairly clear about the advice that went up. That was canvassed at some length. It also seems clear, though, that the Minister took a different view to the advice, and what we don't know is what his view is based on. And in the context of this urgent inquiry before us, how are we to treat such significant decisions being made in relation to a significant taonga with no real evidence supporting the key policy rationale behind that approach?
Yes, so again, this is a matter that we can address in our closing submissions. As Ms Marsh answered today in relation to my own questions, she explained what she understood from her engagement with the Minister, and one can see in the documents, for example, that the Minister's view is based on internal political discussions at the time. And I can...
Well, I'm not sure if we know that, do we? We know it's based on a discussion that he had at the time the Act was passed. Are you talking about the parliamentary intent? We don't know if that was a political discussion or not, because he wasn't an MP at the time.
Well, he is described in the papers. It's described in the paper as an internal political discussion. He had stood for Parliament previously. He was standing for Parliament that year, and what is referred to as internal political discussions. And so, I don't think I can go further than saying the Minister was then involved in politics by that point, having stood previously unsuccessfully for Parliament and standing that year, the year in which the Act was enacted. And so the reference to internal political discussions is a reference to the Minister having discussions where he is involved in politics, although not as an MP at that point.
Yes, it's very opaque.
Yes. Well...
What we do know is he wasn't a sitting MP involved in the passing of the legislation.
That's true. So I understand Your Honour's point in terms of what is available on the record, and then Your Honour's next question will be, and so what are we to make of that? And that is, and we have had the we've had the exchange previously about the tribunal's ability to draw conclusions on the basis of the material that is put before it. And I'll address that again in the Crown's closing.
Thank you, Mr Stevens. Those were the only comments that I had, and I look forward to receiving those written submissions.
No, kia ora, sir. Tēnā koe.
We don't have any further questions for you, but again, thank you, Mr Stevens, and I want to acknowledge you and your colleagues for assisting us throughout the course of this urgent inquiry, as have all claimant counsel. And most importantly, to acknowledge the claimants themselves, those who have both appeared before us, have answered questions from the Crown and from this tribunal panel, and also those many claimants who haven't attended, but who no doubt have been watching keenly through the live stream that has been occurring. We are certainly under no illusion as to how important this issue is and the urgent timeframe within which we need to respond. So with that, can I please encourage Council to ensure that you comply with the very tight filing timeframes, given that we have an equally tight turnaround period in which to produce a report. Ka nui te mihi kia koutou katoa. I will now hand things over to our papa to close the hearing.
Kia ora tātou. Kua tae tātou i te pito o te nohanga o tēnei rōpū whakamana i tiriti o Waitangi ki te kaupapa. Kua kōrero hia e tātou i roto i ngā rā e toru. E mihi ana kia koutou ki ngā māngai, ki ngā roia, ngā māngai o ngā kai kreme, ki ngā kai kere me koutou e noho noho mai nā e te pakitara o muri, ka mihi kia koutou, ka mihi hoki ki te krauna, tātou katoa. I noho ai tātou ki te kōrero i te kaupapa nei, e hara i te kaupapa māmā, e kaupapa ka noho tātou ki te whakaaro ato na wā e putai he māramatanga e putai hoki, heri puata mā te rōpū whakapana i tiriti o Waitangi. Engari, e mihi ana ki te kōunga o ngā kōrero i putai o koutou i ngā roia, i tēnei rā. Me ngā rā ka pahurea ke nei. Nō reira, ko te tūmanako, kia hoki pai atu koutou, kia wehe pai atu koutou ngā mea, no waho atu o te whanganui atara, tātou katoa. Kia hoki pai tātou ki o tātou kāinga, tātou i haere ora mai nei, kia hoki ora tātou kia tai ora tātou ki o tātou kāinga, me o tātou whānau. Nō reira kia taki nā kehekara kia whakamutunga mā tātou. Mea ngā tu o tātou ngā kaukatoa kia ihoa ka irera nei te āwhina mō tātou no ihoa te āwhina mō tātou no te kaiha o te rangi o te whenua. E kore ia e tuku i o tātou wai kia neke hia e kore tō tātou kaitia ki e moe nā e kore te kaitia ki o i haraira e parangia e moe. Ko i hoa tō tātou whakamaru i tōna ria matau e kore rawa tātou e pākia e te rā i te wate e te maramara nei te pō, mā i hoa tātou i tiaki ngā kino katoa mānai tohu o tātou wairua. Mā i hoa i tiaki o tātou haere ngā tō tātou hoki na mai āienei āke, gloria ki tō e ngatapu. Amen, everyone. Amen.
Amen. Kia ora matua.